Good morning. We're now going to open the Criminal Justice Public Safety Committee. I'm going to call the meeting to order. We're now going to open the public hearing on HB 1349, which is decriminalizing the possession and use of mushrooms. Before we begin, Representative Marston, do you want to lead us in the Pledge of Allegiance? Representative, you do need to complete a pink sheet. Everyone know how to use the microphones? You push the button on the right. When the red light goes on, so is your mic. If you're not recognized to speak, please keep your microphone off. I never say anything inappropriate, so it doesn't matter to me. We only would need one if we were a quorum if we were going to have an executive session. So we would need to have, I think, 11 members present in order to have an executive session. We have no bills to exec, so we're going to begin with or without the majority, well, large number of the people. At this time, I recognize that Representative Tony LaBranch to testify and offer, introduce HB 1349.
Let me take this off to begin with. Thank you, Chair Abbas, and thank you, Criminal Justice and Public Safety Committee, for allowing me to introduce my bill today. I believe it's important to start with definitions before I introduce HB 1339. I know a lot of you probably already know, because this is the Criminal Justice and Public Safety Committee, what the difference is between decriminalization and legalization. In this case specifically, decriminalization means that we're not putting people in prison for simply possessing hallucinogenic psilocybin mushrooms. There are many reasons why this bill came to be, and one of those reasons is I don't believe it is the role of government to tell people what they can and cannot do in their own homes. Hallucinogenic psilocybin mushrooms have been found to be some of the safest recreational drugs, even compared to alcohol and cannabis. This drug is safe. It doesn't make sense to me why alcohol should be legal when this drug is safer. The cost of incarcerating one individual in New Hampshire is about $54,000. That's not even including prosecuting them. I believe that the state has better things to do with that money and go after the dealers of hard drugs instead of going after individuals who simply possess and use psilocybin mushrooms. I don't believe it is a crime in itself to possess them, or should not be a crime to possess them itself. We have seen in other countries that have decriminalized other drugs, such as Portugal, which legalized, or I should say decriminalized every single recreational drug. Drug addiction rates fell by 50% because individuals felt comfortable to get the help that they need without fear of being prosecuted. The use of drugs in itself is a victimless crime, especially when it comes to mushrooms. If you're using it in your own home and you're not bothering anybody else, why should it be a crime? So this bill specifically follows what we did with marijuana in the state of New Hampshire when it comes to decriminalizing it, and it follows the same framework. You can still be fined for having mushrooms if you're walking around in public or driving, but you will not go to prison, at least for your first 3 offenses. And that's what this bill does. And I'm happy to answer any questions.
Representative Testman, you're recognized to ask a question. Representative Bournet, do you need the microphone turned on? Is that?
I need to turn it on. Okay. How many prosecutions or arrests do we have for mushrooms per year in New Hampshire?
That is information that I was not able to get from OLS, but I will say that even one prosecution, that's $54,000 to incarcerate, plus the time and money that we use to prosecute these individuals. There's better things we can do with those resources than prosecute these individuals, because we should be going after the dangerous offenders that are, selling heroin and other hard drugs. I don't think that the possession of these relatively safe recreational drugs is the way we should be going in the state of New Hampshire.
Representative Roy?
Thank you. Thank you for taking my question. You've made a statement a couple times about regarding the safety. Do you have any studies or other evidence to present to the committee that would indicate how safe these drugs are?
It was my intent after this hearing to send out an email with all these studies that I have been collecting.
Thank you.
Representative Bolden?
Hello, thanks for taking my question. In addition to whatever you're planning to send to us, can you ensure that there's something that specifically speaks to the claim that it's safer than alcohol? Because
Yeah.
that would be good to be able to verify.
Yeah, there are multiple studies that I can send out relating to the safety of this drug.
Follow up, Mr. Chairman.
Representative Bolden, recognized for a follow-up.
And additionally, could you send something about the cost to incarcerate?
Yes, that I found in the fiscal note, which stated that it costs $54,000 a year to incarcerate individuals in New Hampshire.
Then I already have that. Thank you.
Thank you, Representative True, you're recognized.
Thank you, Mr. Chair. Thank you for taking my question. I'm wading through the bill. Can you show me where in the bill it references the fine for three possessions, decriminalizing third possession fines, what the fine is?
It is, I have it right here. Under 318-B:2-F, psilocybin mushrooms, if you go to section 4A, it says that the first fine is $100. The second offense under this paragraph is $300 and any subsequent offense. And after three times of being caught with possession, it would be a 3-year, or it could be a misdemeanor in this case.
Thank you.
Thank you, Representative. You're excused. This time, the chair now recognizes Ian Freeman.
Good morning. I'm here to speak in favor of this bill as a minister with the Shire Free Church. You're going to hear, I'm sure, a lot in emails or various different testimony that might be sent to you about the safety of psilocybin mushrooms, and they are indeed very safe. Professor David Nutt, who is the former, basically, drug czar of the UK came out with a chart back in 2010 that measured the relative harm of each drug that is prohibited. And in his case, he was in the UK, but they still prohibit most of the same drugs that are prohibited here in the United States. And it's a very comprehensive list with alcohol and drugs. They categorized harm based on the harm to the individual user and also harm to society. At the very bottom of the list is psychedelic mushrooms, which is what we're talking about here. It's actually lower on the list of harm than cannabis, which has, as you know, already been decriminalized here in New Hampshire as of 2017, and New Hampshire hasn't caught on fire as a result of that, so everything's okay. This bill goes in that same direction. Psychedelic mushrooms are also therapeutic. There's plenty of studies. There's a mountain of studies that have been built on this. It has helped people with PTSD, with depression. Many military veterans have actually solved their PTSD through the use of psychedelic mushrooms where no other treatment has been able to do that. These things are natural, and I shouldn't have to point out the absurdity of criminalizing nature, of making it illegal to have something that grows naturally. And it's something that humans have been using for thousands of years all across the planet. But the one thing I really wanted to focus on today is the fact that if you guys pass this bill, and you should, you're actually just going to be following along with what the New Hampshire Supreme Court has already decided. Distributed, I want to bring your attention to the Supreme Court of New Hampshire, a case that was issued in December of last year. It is called State of New Hampshire versus Jeremy Mack, M-A-C-K, Mack. Mr. Mack is a member of the Oklevueha, if I pronounced that correctly, Psychedelic Church. It's a Native American church out of the West, and he was arrested for possession of psychedelic mushrooms in New Hampshire, was convicted at Superior Court. He appealed his case. The New Hampshire Supreme Court ruled unanimously to overturn his conviction. The New Hampshire Supreme Court said, and I'm summarizing here, a 22-page opinion, but basically that New Hampshire's Constitution actually goes further than the U.S. Constitution, which one of the things we love about New Hampshire, where we love freedom here. The New Hampshire Constitution protects people's right not just to religion, but their right to worship. And obviously the Supreme Court of New Hampshire agreed, again, ruling unanimously to overturn this man's conviction for possession of mushrooms. And just, it's just a couple of sentences. I'm going to read it to you. This is from the New Hampshire Constitution. It says, every individual has a natural and unalienable right to worship God according to the diktats of his own conscience and reason, and no subject shall be hurt, molested, or restrained in his person, liberty, or estate for worshiping God in the manner and season most agreeable to the diktats of his own conscience, or for his religious profession, sentiments, or persuasion, provided he doth not disturb the public peace or disturb others in their religious worship. So if you're at home, or you're in a safe place, which is of course the best place to do a psychedelic of any sort, is a safe setting, then you're not disturbing the public peace. And so according to the New Hampshire Supreme Court, that's legal here in New Hampshire. So the statutes against this need to be changed to catch up with this Supreme Court case. I'm happy to give this to whoever needs to get it. If you want to get copies out, it's like 20 pages. So with that, I'm happy to take any questions. Oh, one other thing, I do feel as though this bill is a good step in the right direction, but it ultimately doesn't go far enough. What it should be done is there should be an amendment put forth to actually decriminalize all natural things. So not just mushrooms, but there's other things that grow on Earth that are also prohibited, and those should be included in this. But as is, it's pretty good. I support it. So happy to take questions.
Representative Roy?
Thank you, Chairman. Thank you for taking my question.
Sure.
You referenced the military and PTSD. Are you aware of whether or not if the VA has experimented and used this as a treatment officially for veterans?
I am not. That's an excellent question, but there have been a growing number of studies with larger and larger sample sizes that have been coming out over the last couple of decades. The FDA has been authorizing these studies to become larger and larger, so we're starting to finally see some of the really interesting applications for therapeutic use of drugs like psilocybin.
Okay, follow up, please.
Representative Roy?
Thank you. Similar to cannabis, regardless of what we decide to do, this would still be illegally federally, correct?
Well, of course, that's correct. The federal system is slow to change, even slower than the one here in New Hampshire. However, of course, we've seen as cannabis has been legalized and decriminalized across the country, the federal government has been reticent to really put a heavy hand down on the states that have moved in this direction. So I wouldn't worry about them in this case.
Thank you.
Representative Testament?
Thank you for taking my question.
Certainly.
You were reading that decision. It seemed to allude to a person practicing religion. So do you have to get a certificate of your practice of religion to use these drugs? I mean, how do you separate the two?
Well, in Mr. Mack's case, he did have a membership card for the Oclavuela Church. I don't think you should have to have a membership card to prove that you have a religion. I mean, ultimately, as long as you have a religious belief and you're willing to assert that, these things are very, in my opinion, in my experience, very spiritual practice. So the use of psychedelic mushrooms goes back for many, many thousands of years for spiritual reasons.
Recognized for a follow-up?
But you based a lot of your testimony on the religious clause in the Constitution. How do you tie that to a person who is not religious and the use of this drug? I'm not disagreeing whether it's right or wrong. I'm just saying you tended to tie them together, and I'm not sure that's logical.
Well, you're certainly correct that people's reasons for using these things differ. Okay, so a religious use is going to be different than somebody who wants to take a drug at a party or something like that. But either way, it's immoral to put somebody in a jail cell for doing something to their own body, just on a fundamental basis. Now, there's more responsible ways to use these things, and there are irresponsible ways to use these. You should not get behind the wheel of a car, for instance, while doing this. So being in a safe setting is very important. And in my experience, the use of psychedelic mushrooms, this isn't a party drug for the most part. This is a very introspective experience. You're much more likely to not want to talk to people. You're much more likely to want to go inside oneself and look at yourself and look at your experience in life. And it's just not, it's not a party drug generally. But even if somebody were to take this at a party, that should not be a criminal act. And it just doesn't make sense to spend taxpayer dollars to put that person behind bars. It's not helping anyone.
If I may inquire with a
Sure.
question, and thank you for taking my question. In the bill, it has a possession limit. It would be 12 grams. Approximately how many doses would that be?
It's a good question. A very strong dose of mushrooms is probably about 3.5 grams, generally considered to be what they call 1/8 of an ounce. So 12 grams would be enough to, you know, have a few different doses on hand in your house. And that seems like a reasonable limit. Obviously, I'm not in favor of any kind of limits or any kind of drug prohibition at all, but we have to take, you know, it's politics. You have to take steps, and this is a good step in the right direction.
Thank you. Representative Lang?
Thank you, Mr. Chair. I guess my question is, I know when we're having a marijuana discussion, they're talking about marijuana is not sure marijuana of the 70s or 60s anymore, that it's been, you know, modified and grown through various reasons to increase potency. Can the same thing be done with mushrooms? Are we just talking about You know, are there ways of enhancing potency, and does that have any different effect?
That's an interesting question. I mean, mushrooms are such a strong experience. I mean, it's a very, it can be a life-changing experience to take mushrooms. So what science can do, what technology can do to modify that, I can say this, I have come across a liquid psilocybin in the black market. And it's very interesting because generally when someone takes mushrooms, one of the downsides of dosing on mushrooms is that you might puke. It can be a very upsetting experience. If you have any food in your belly at the time, there's a good chance that's going to come up. So it's usually best to take it on an empty stomach. The liquid product actually gets rid of that problem. So there have been some technological developments that make it actually easier for people to take this and have a better overall experience.
Follow up, Mr. Chair? Follow up, Mr. Chair?
You're recognized.
Thank you. So again, does that alter, you know, in any way your thoughts on legalization, as if we allow for this generic conversation of psilocybin mushrooms, in making it stronger and dealing with, you know, again, alterations of nature, so to speak, to make it more potent, does that have any impact on your thoughts on legalization?
Actually, I think that this development of the liquid that I mentioned to you is a really positive development because when you normally are going to take a dose of mushrooms, you really have no idea the potency. You can, when you look at them, you can say, well, this one's bigger than the other one, but it may or may not have more psilocybin in it. And ultimately, that's the chemical that we're talking about here that is the psychedelic chemical or the entheogenic chemical. So you can't just weigh 3.5 grams and say, oh, well, this is going to be a good dose. It could be the strongest dose you've ever had in your life, or it could be incredibly weak. You just can't tell one to the next. But the liquid version, you can actually measure the dose very accurately. And so that allows someone to be very sure and very certain the level of an experience that they're going to have, which has been previously unavailable in the black market. So that's a technological advancement that is very, very good for people because if you want to, there's something that's been more popular recently called microdosing, where it got kind of popular out in Silicon Valley with tech people where they would take a very small dose of a psychedelic like mushrooms, maybe 1/10 of a standard dose, and they would be able to go to work and they'd be able to be productive and they wouldn't want to like curl up in a ball and, you know, go inside themselves. It was a much different, more productive experience for them. So to be able to measure a dose means that it can be used in a much more medicinal fashion. So I think that actually is a positive development.
Representative Roy?
Thank you. Thank you for taking my question again.
Sure.
Is it possible to overdose on psilocybin?
There has never, to my knowledge, similar to cannabis, ever been someone who has died from overdosing on psilocybin. I mean, any amount of this thing is a strong experience. I mean, if you take a normal size dose. So there's a natural tendency to not want to do that because it's very strong in general.
Thank you.
Thank you for your testimony.
Thanks for listening. Is there someone I should give this to? This court case secretary or something who can?
You can hand it up and.
Okay, thanks.
This time, the chair recognizes Lieutenant William Bright.
Good morning. For the record, my name is Lieutenant William or Bill Bright with New Hampshire State Police. I oversee the narcotics unit of the state police. I'm here to represent the state police in our opposition to this bill, and that is simply for the public safety risk that we believe it would entail. In general, decriminalization of a drug will lead to greater use, some experimentation, which will also lead to some more infrequent impairment in public by way of, on our roads, driving, exposure to children, and just general public intoxication. It was mentioned in the previous testimony that there's no idea, no way to judge the potency of a dose of a hallucinogen. which I think is something that should be of concern because it's unpredictable. Hallucinogens are unpredictable by nature as far as the reaction that somebody will have when they take one or try one, which could lead to making poor decisions, as well as just the general exposure to the children in our community. I know from my experience, my children have told me that there are already hallucinogens or shrooms in the schools that they are in, which is concerning to me. It was also said in the previous testimony that use by somebody in their own home. That would be great if that was the case all the time, but in general, that will not be the case. If it's easier for somebody to possess psilocybin mushrooms, it's going to be easier for somebody to use that in public, and it won't always be taken in a safe manner. With no way to regulate the dosage levels that somebody takes, we just have a concern for the public safety risk. That's my testimony, and I'm willing to take any questions.
Representative Roy?
Thank you, Mr. Chairman. Thank you, Lieutenant, for taking my question. Are you aware, is there any type of a test that an officer could administer, part of a field sobriety test to tell if someone was under the influence of these drugs?
Nothing that I'm aware of specifically for psilocybin. Obviously, we can do impairment tests just like we do with alcohol or with marijuana or any other drug. We have drug recognition experts that are at times able to determine what type of drug it appears that somebody is impaired with, but I'm not aware of a specific test for psilocybin mushrooms.
Follow up, please. Thank you. So it would be safe to say that if somebody were under the influence of these, it would be impossible to tell exactly what was affecting them other than the educated guess from an officer?
To my knowledge, yes.
Okay. Thank you.
Representative Newman?
Along the lines of the question that was just asked, how big of a problem, I don't want to call it a problem, how often do law enforcement officers run into things where these types of mushrooms are involved?
In my experience, and I haven't been on patrol for about 10 years, but in my experience, over the 20 years that I've been in law enforcement, I have not seen it often. But I do, as I said before, I mean, I know my own children have told me that they've seen these at school. Maybe not personally seen these, but know that people are using them, children in the schools.
Representative Newman?
And do you have any insight you might give us based on conversations or things you know about other people, or just in general, what you might think how often this is a problem in the state or anything like that?
I don't have any specific thoughts on that, but I would just say that in general, if this is decriminalized or legalized, whichever term you want to use, there will, in our experience, there will be more experimentation, there will be more use, which will lead to a greater public safety risk.
Thank you for your testimony.
Thank you.
This time, the chair recognizes Bonnie Kraus.
Hello, my name is Bonnie Cruz. I'm an activist and volunteer from Keene, New Hampshire. I founded Decriminalize Nature New Hampshire with my friends because I have personal experience within theogenic plant medicine, and I believe it is the answer to so many problems facing our community, New Hampshire, today. We're living in a time of extremely high rates of anxiety, depression, addiction, and suicide. And medical practitioners are at a loss trying to find things that can help people. Entheogenic plants and fungi, such as psilocybin, have been showing promise in studies and therapeutic office settings around the country already. Many military veterans who have come back from wars with severe PTSD have found that only entheogens such as psilocybin can help them, such as Adam Kokesh from Arizona, who uses psilocybin and gifts it to other military vets with his church legally. He helps vets that are suffering all around our country. Justin O'Donnell from here in New Hampshire, he contacted this committee via email, and he's also a veteran in favor of this bill. People contracted by the government to put their lives on the line for the government in wars, like my dad and grandpa, should at the very least not be stopped in the state of New Hampshire from getting the medicine they need for their trauma. This bill ought to pass because it will directly relieve Granite Staters from the trauma of being punished by the court system for simply possessing psilocybin mushrooms. Possessing and even dosing yourself with psilocybin hurts no one and is therefore not a crime. Our ancestors used this medicine for thousands of years safely. Alcohol is legal to possess in the United States, and many of us have seen its ill effects. I don't believe that we need that many studies showing its ill effects. Everybody in this room has probably seen at least somebody throw up from using alcohol and make bad decisions. But decriminalizing it did make it safer, or, legalizing it's legal. It did make it safer than when people were making bathtub batches and moonshine. And that's what decriminalization will do for psilocybin as well. The lieutenant suggested that it's going to make the whole state less safe because it will be more widely used. But really, if it's not, people aren't being gone after for possessing it, then the problem that Ian Freeman and the lieutenant mentioned of dosing can actually be fixed without people being afraid of going to jail for that. I've seen psilocybin's positive effects, and I'm asking you to please pass this bill to decriminalize it. Thank you.
Representative Roy?
Thank you, Chairman. Thank you for taking my question. The bill talks about legalizing, or not legalizing, decriminalizing the possession of it. The problem is that the dealing of it would still be, the selling of it would still be illegal. Where would one go to get psilocybin and know that it's safe?
Well, I don't really know the answers to that. I didn't see in the bill anything about the sale of it.
Okay, all right, thank you.
Thank you for your testimony. At this time, the chair recognizes Representative Kevin Verville.
Thank you, Mr. Chairman, members of the committee. Good morning. I don't know how many of us know the history of psychedelics. I know some of it. And so psychedelic mushrooms, cacti, other substances have been used for thousands of years by humankind safely and effectively. Dr. Albert Hofmann, working for Sandoz in Europe, synthesized LSD for the first time in the 1950s. In fact, Sandoz commercialized LSD as Delicid, and you can still find the brochure online. So psilocybin, mescaline, LSD, they're all very closely related. It was the advice of Sandoz Pharmaceutical to doctors to administer a dose for therapeutic use and to double the dose each session until the desired effect was obtained. So it's very interesting dosing recommendations. In fact, the US government became very interested in psychedelics, particularly the military and the CIA. Unfortunately, their desires were truth serum and population control. The experiments were abandoned, and the position on psychedelics was reversed when it was discovered that users of psychedelics become peaceniks. And in the 1950s and the 1960s, the U.S. government, for various reasons, was not interested in turning average citizens into what we would now classify as peaceniks. Psychedelics were first made illegal in the United States by Democrat governors of Western states, namely Nevada and then California. And that was a knee-jerk reaction to growing public interest in psychedelics at the time. The federal government quickly followed suit with an iron curtain against all psychedelic use and medical use, personal use, and research. In fact, federal research on psychedelics has only come back in the last few years. These compounds are essentially considered to be non-addictive. And for the record, so I support the bill in case you haven't figured that out. I should have led with that. I believe in the decriminalization of most, if not all, psychedelic compounds. I am not a general legalizer of drugs. I don't believe that amphetamines, I don't believe that barbiturates, I don't believe that opiates, I don't believe that other compounds should be legal. And the reason I don't believe that is because I believe that there are more drugs. What's a more drug, you ask? A more drug is a drug that the more you do, the more you want to do. They're highly addictive and essentially destroy lives. Psychedelics do not fall within that classification. We've already heard testimony on the therapeutic use, so I won't beat that up. I'd like to thank the previous speaker for making note to the committee that prohibition does not work. And in fact, if your finger is on the pulse of American youth and older people, psychedelics are currently in a renaissance in the United States. Psychedelic use peaked in about the 1980s in the United States, and we are slowly approaching those levels again because of the renewed interest. Prohibition does not work. If there are psychedelic mushrooms in the schools, then that tells you everything you need to know. The challenge that we have is that we're producing felons, young age felons. If you get caught with psychedelic mushrooms, with psilocybin mushrooms, if you get caught with peyote, which contains mescaline, or if you get caught with LSD in any form and you get convicted, you are a felon. That is very bad policy because there are no other crimes other than possession that are typically associated with the use of psychedelics, right? I think we all agree that we want young people to be able to approach law enforcement as well as the criminal justice system in an open and honest fashion. I want my kids, I want your kids, I want all kids to feel like they can approach the police for help if they need it. And if I've got a bag of mushrooms in my pocket, I can't do that. Because if the situation takes a turn that's unpredicted and I have to empty my pockets and I'm convicted, I'm a felon. And that destroys my life. Growing up, I didn't trust the police. And that haunted me for years of my life because I didn't realize why. And the reason why was because I made lifestyle choices that essentially made me a non-convicted felon, right? I should not have had to fear the police. If we want to heal that relationship between young people, young adults, because those are the primary users, one of the steps we should make is to decriminalize most psychedelics. This is a step in that direction. This is common sense, bipartisan legislation. I took some notes. So the dosage question. The dosage question is very, very interesting. Psychedelic mushrooms are mycology. It's a study of fungi. To the best of my knowledge, nobody has been successful in selective breeding of mushrooms to increase the potency of the mushroom. various psilocybin mushrooms by strain contain various amounts of psilocybin, and typically users know which is which and will go shopping, will choose product for a given effect. Not on the table today, but interesting to consider, that the dosage of most LSD on the street is considerably lower today than it was in the 1980s. It's anecdotal. I can't give you the scientific research that shows that the dosage of blotter acid goes down. But if you're familiar with users from then and now, and you interview them, you'll know that to be a fact. So interestingly, the dosage for psychedelics has been going down. And in fact, one of the biggest things in vogue today is to microdose, is to not take the large dose for the very heavy introspective effect, but rather a very small dose to try to encourage creativity of the mind. The development of liquid psilocybin, or psilocybin carried in a liquid form, is not a new development. Dr. Hoffman, who we heard about earlier, was also successful in synthesizing psilocybin in the late 1950s. So synthetic psilocybin has been known for a long time. It is, to the best of my knowledge, never been commercialized because the production of mushrooms, of fungi, is much easier to do, and that has been the effect. I don't know it for a fact for psilocybin. I would have to double check. But LSD, a very close relative of psilocybin, you cannot, repeat, you cannot overdose on LSD. And I believe that is true for psilocybin, and I will try to find the reference for that and get it to the committee. Right? Remember that. You cannot overdose on LSD, and I believe it's true for psilocybin. In the United States, it's very easy to produce these mushrooms, both indoor and outdoor. And the possession of spores, which is essentially the seed, is not illegal. Repeat, the possession of psilocybin mushroom spores, or the seeds, is not illegal because the spores do not contain psilocybin. They do not contain the active. So it's virtually impossible to stop the production. Previous speaker spoke of public safety. When people have to hide, when people fear getting help they may need for whatever reason, you put the public at far greater risk under those conditions than you do by decriminalizing a compound that's in use, that's in our society, that's readily available. Right? I don't think minors should be doing this, but they are. And we shouldn't do anything that puts them at risk. I would strongly encourage that this committee pass this bill so that we can decriminalize psilocybin mushrooms as a step in the right direction. If we think about other bills that we've passed, other laws that we've changed, this is going to be akin to that. When we passed constitutional carry, there were cries there were going to be shootouts in the streets. Never happened. When we decriminalized marijuana in New Hampshire, pot use was going to run rampant. Society was going to collapse. It never happened, right? This bill will have the same effect. I thank you for your time, and I would be more than happy to take any questions any member of the committee may have.
Thank you, Representative. I'm going to first recognize myself for a question. Setting aside the policy issue of whether or not we should make this legal or illegal, from a logistical, mechanical standpoint, we know that many drugs are sold that have been laced or tainted, or, for example, we're having trouble with fentanyl. being introduced into certain drugs and the user not knowing it and overdosing. And whether or not the point of you can overdose or not, the question I have is, mushrooms in and of themselves, some of them are extremely lethal. How would someone know that they were getting a safe product if we make this legal and there are people dealing it and someone buys it and they end up getting something that's poisonous? I mean, the bill doesn't speak to distribution, it only speaks to possession. So how can we ensure public safety if the dealing of it's still illegal? So it would be black market. And like I said, some mushrooms are extremely lethal, even in tiny doses. So how can we ensure that people aren't getting, which is already happening with other drugs, something that they didn't intend?
That is a fantastic question, Mr. Chairman. I appreciate it. Some of you might have deduced that I follow this subject rather closely. I am not aware of any incident where any psychedelic substance was adulterated with any other material. So I would challenge anybody that would allege that that is a possibility, not a possibility, but a problem, to find one instance in the United States where that has occurred. But our focus is a little more narrow, and it's psilocybin mushrooms, right? And there's an old wives' tale out on the street. The more blue, the more potent the mushroom. That's not true. But these mushrooms, when bruised, do turn a very blue color. They have a relatively unique appearance, and all psilocybin mushroom strains appear more or less the same and are relatively easily identifiable. It's my belief that the producers, as well as the users of psychedelics, are not motivated by profit. They're not in it for the money. And so when we look at things like heroin and cocaine, maybe to a lesser extent things like methamphetamine, those drugs are being adulterated with cheaper compounds, less expensive compounds that require less to be added, and the street price remains the same. So it's to drive up the cost. Psilocybin mushrooms, LSD, on the open market are very inexpensive drugs because the producers, the dealers, and the users are not interested in the financial aspects. I mean, everybody makes some money, but I don't see that as an issue. I've never known anybody to get a fake mushroom. Now, there are some hallucinogenic mushrooms that grow naturally in New Hampshire, right? Pinalias, there's another type, I only know them by the common name Laughing Jims. And those are not criminalized compounds because they don't have the psilocybin. So there are other naturally occurring mushrooms in New Hampshire that one can take for such an effect. I hope I answered your question.
Thank you. Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question. I'll be very impressed if you know this answer, so I'm asking if you could find out this answer. When Nevada, California, followed by the federal government, banned this, who were the lobbyists behind the banning of this? Because I know, like with the marijuana, it was the alcohol lobbyist that wanted marijuana. So if you do know, that'd be great if you do know. And I do have a follow-up.
Thank you, Representative. It's a good question. So certainly, federal authorities, particularly military and intelligence, had soured on psychedelics that they were researching. So MK Ultra, right, was the program of psychedelic research, and you can Google that and learn all about that. The governors, I think, were mostly motivated. So the genie got out of the bottle. The feds were testing. They had loose controls, and their test subjects found out with what they were being dosed, figured out that if you can acquire lysergic acid, you can produce lysergic acid diethylamide quite readily, quite inexpensively. And because it turned people into peaceniks, because of the experience under psychedelics that the vast majority of people have, there becomes this evangelistic drive in some people to spread the word that if you take this, you will see the universe for what it is. You will understand the universal oneness, and you will understand we are all related, we are all brothers and sisters, and we are not just related as people, but as everything. We are essentially the universe trying to realize itself. That's the experience. Mass production began in labs. Street lab's a bad name, right? Because the purity of the material was very, very high. And so there were things called acid tests where if somebody chose to go, you take a small cup of the Kool-Aid and you have the experience. The peace generation, the anti-war movement was really getting ginned up. It was tied to the psychedelics. And so it was really, I think, an attempt at governors for a law and order, can we just get back in line and go back to pretending it's 1958 again, I think was a very large driver. And there was a huge misunderstanding of what psychedelics are, what they do, and how they work. I can look into it, but I can't, at this point, I can't guarantee that that's readily available. Thank you.
In a follow-up, Mr. Chairman? Thank you, Mr. Chairman. Because I always wonder, I always follow the money. So, usually something's banned because somebody wants to make money somewhere else, like alcohol. Now, the lieutenant said that testified, said that his own children, didn't see any and has never taken it. That's good. But said that it is in their schools. How available is it in the school? Is it equal to marijuana, which I heard is just rampant in schools?
So I would tend to agree that marijuana, cannabis products are very readily available, particularly at the high school level. It's my understanding from reading, news reports and following what's going on. The United States is in a psychedelic renaissance. These things are fairly easy to obtain. A lot of people have used them. There's certainly people in this room right now that have used them to no ill effect, and simply want to stop the possibility of making felons. The last LSD arrest I heard of in New Hampshire was a couple of kids in Manchester. It was a boy and a girl on a date, high school aged. They chose to hang out for whatever reason in a cemetery. They were in the car, just hanging out together, having their experience. The police noticed a car in the cemetery after dark. They went, they investigated. Somehow they found a few hits of blotter acid on the young man, and he went to jail. He's a felon for life, right? And they weren't doing it. They picked a bad spot to be because they felt they had to hide, right? And so those lives are ruined. And this bill is to try to fix that. And that's why I support this bill. The only amendment I would offer to this bill would be to add LSD and mescaline to the list. But again, maybe that's a bite too far today. And so I think this is a good first step in the right direction. Thank you, Representative.
Thank you.
Representative Bolden.
Thank you. Thanks for taking my question. I'm sorry if you already covered this, but what's your perspective on changing the bill to make the age 21? Do you think that the drawbacks there, because based on the story you just shared, do you think that the drawbacks are greater than maybe some of the benefits as far as being able to pass the legislation? Thanks for taking my question.
Thank you for the question. And it's an excellent question, right? And so the question is, what step in the right direction can we take? Adults, particularly when you get up into your 30s, 40s, 50s like me, you learn how to live within a system that may not approve of what you do. And you can take prudent action to avoid trouble. Young people are not as savvy at doing that, right? I mean, we all know the joke of the drug deal in the hallway. Oh, look, you know, they're exchanging pot. I mean, let's not kid ourselves. We know what that looks like. They think they're being discreet, and they're not. They're actually drawing attention to themselves. This bill doesn't directly help those people. It doesn't. Probably 18 would be a better age. I think the prosecution of minors with psychedelics, you know, is probably a little lower. I'm not an expert in that, but the bill probably would be better with no age specified, but I think that would probably be found to be unpalatable because of the belief, and I think it's a misconception, I don't believe there's any truth to it, that if you did that all of a sudden, you know, 8-year-olds and 12-year-olds would start taking psychedelic mushrooms. Most people are very apprehensive about taking these compounds, particularly for the first time, because of the lies that have been told about these compounds for decades. When I was in high school, when they gave us our drug education program, they made it sound like if you took a psychedelic once, you know, you stood a good chance of ending up in what used to be the New Hampshire State Hospital for the rest of your life, right? That simply is not true. I mean, can you find a case here or there where somebody has an adverse reaction? Yes, but that's true with almost anything. But the vast majority of users, that is not true. And most people, I believe, begin to experiment with these compounds in the high school years, typically the second half. And so that age group is selected out. I would prefer to pass something that we can pass to allow the data to be collected that making this change does no harm, right? This bill will do no harm. And then, once we see that, we can look at perhaps expanding depth and breadth of the legislation, if that answers the question.
Follow up.
Thank you. It seems like you obviously have a personal connection with the subject matter, and a lot of your commentary has been sort of ideological. Do you have any commentary on the fiscal impact of passing this legislation?
Yeah, that's not my bailiwick, to be quite frank. I think the fiscal note's pretty clear. It's expensive. To make somebody a felon for possessing psilocybin mushrooms and to throw them into the state prison for any period of time or any other place where they have to be monitored or they're incarcerated is expensive. And in my opinion, there is absolutely no value in that to society or the state. And so this bill, I believe this bill is a harm reduction bill for the general public, and I think it should be passed. And I hope that answers your question.
I recognize myself for another question, if you don't mind, Representative. And I asked this earlier, with regard to the contradiction between state and federal laws, even if we were to make this decriminalized in New Hampshire, it would still be a federally illegal substance. And there are a lot of ramifications for that long-term for young people. So if a young person does psilocybin, he would be automatically disqualified from a lot of different careers in their future. Anything that required a security clearance in the military, he would never get. He'd be disqualified from serving in law enforcement where the polygraph's administered. So there's a lot of long-term effects with breaking a federal law, even if it's not illegal here. What are your thoughts on that contradiction and the impact that could have on young people that they don't realize down the road they've just ruled out a whole set of career field potentials?
That's an excellent question. And I agree with the previous speaker. I don't believe that the feds have any interest in the individual user or a small group users. I don't believe they have any interest in that at all. If you are like the gentleman up north that was growing mushrooms for restaurant use and happened to have a back room that he did not fully disclose and was producing relatively large amounts of psilocybin mushrooms, I think the feds become interested in that. There are, at this point, many communities that have decriminalized psilocybin mushrooms, specific to no ill effect that I'm aware of, and the feds have essentially taken no notice other than to put out press statements that they don't approve of it and it shouldn't be done. You know, if I got caught, if I left here and I got picked up by our friends in law enforcement and was found to be in possession of, say, 1/4 of an ounce of psilocybin mushrooms, I doubt that I would be brought up on federal charges. I would be brought up on state drug charges, and I would end up just north of here. Would be my guess. Now, if I got pulled over and I had, say, 100 kilos of mushrooms in the back of a van, that probably would get escalated to a federal level.
I guess my question wasn't necessarily about the prosecution as much as the impact. For example, my own son, he's 16, and I warn him, don't even experiment if you intend, because he wants to be a lawyer, intend on possibly working for the federal government, because you will be given a polygraph. A job where there's a security clearance, and if you admit to the use of, for example, a psychedelic, you're probably going to be automatically ruled out, and that same goes for law enforcement, many things. So when we say, okay, not putting an age limit like 21, where people have a better chance of understanding the impacts of their decisions, that's what I was trying to get your feel for that.
Yeah, so I want harm reduction, and I want to protect young people because they're the ones that are most negatively impacted. I don't believe that we could get a bill passed today, so I would not encourage that as an amendment at this time. Again, because of the way we talk about psychedelics in drug programs, I don't believe anybody takes a psychedelic for the first time lightly. It is a decision that most people think about for a long time before they make the decision to do that. And to be quite frank, the legal status of LSD and psilocybin plays virtually no role in making that decision, because typically first-time users are going to get a dose from a friend. And so their legal risk at that point is incredibly low, right? I take possession, I ingest, and then I'm done. Well, New Hampshire law enforcement certainly has been more aggressive about internal possession charges for minors and alcohol. You would be much more hard pressed. That's an issue. The concern is real. I understand your concern. I just don't see where this bill would negatively impact that.
Thank you. Representative True.
Thank you, Mr. Chair, and thank you for taking my question. The bill deals with criminalization for the possession and the use of psilocybin mushrooms. So my question is, do you feel that this also applies to liquid psilocybin, which I assume might be a manufactured psilocybin chemical? So you feel this also applies to the chemical itself of psilocybin, which I assume would be the liquid psilocybin, or is it just for the physical mushroom that contains psilocybin?
Thank you for the question. So psilocybin is the molecule that is psychoactive. Within a mushroom, there are other compounds, because mycology is quite complex, that also play a role and influence the impact of the psilocybin on the human body. This bill, under my reading, goes directly to naturally occurring psilocybin within fungi, within mushrooms. This bill does not go to synthetically produced psilocybin, which typically would be crystallized as a salt. It's a large molecule. The reason the speaker probably is referencing liquid psilocybin is because it's generally dissolved in a carrier, either distilled water, sometimes an alcohol solution, to make dosing easier. The amount, the physical amount that's required is incredibly small. And so to be able to dose synthetic psilocybin reliably, you have to dilute it so that you can get that control. This bill, I do not believe, would cover synthetic psilocybin, nor do I believe that liquid psilocybin, synthetic psilocybin, is available on the black market to any degree at all. I believe that is primarily being used in the studies that are ongoing at Cornell and other institutions where they're probably choosing the pure compound as it's a little more controlled, although some of the studies are also using mushrooms.
Thank you.
Thank you, Representative. Thank you to the committee for taking my testimony and the excellent questions. And please pass this bill. Thank you.
Thank you. There being no further speakers on the matter, we're going to go ahead and close the public hearing on this bill. And I'm going to open the public hearing on HB 1215, an act relative to the definition of a residual amount of a controlled drug. And Representative Baldassaro is recognized to introduce his bill.
Thank you, Mr. Chairman. For the record, Representative Al Baldassaro, Rockingham County District 5, which is Londonderry. HB 1215, I've got a call a day or 2 days before our submitting bills from, I'm sure you all remember Representative Lynn Blankenbecker. She was the attorney for, hired by the Hillsborough County, John Coughlin, former judge and county attorney. But anyways, asked if myself or French, Senator French, would submit this bill for them because of the many issues they're having in the court system in Manchester, tying up the courts on a certain amount of, I don't know if it's marijuana or what it is. I sent an email to Judge Attorney Coughlin there and asked him to have somebody here because Lynn Blankenbecker got deployed. So she is right now not with the county, as she's somewhere in another undisclosed location doing her military job. So this bill, I really can't answer to it on the legislation because somebody who's not a lawyer, and you will have somebody stepping up here that will be speaking in support of it. And I'm hoping that with the duty experts in this committee, feel free to make an amendments as needed, because there may be a couple of areas on drugs that need to be added in here as, I mean, as I was talking with the chairman on, like, the fix to make sure that it's not covered in this bill. And like I said, there will be somebody stepping up here to speak, and I'm not sure if anyone is here behind me from Hillsborough County Attorney's Office there. So, and that's basically all I have, the reason why it's brought it forward.
Representative True.
Thank you, Mr. Chair. And thank you for taking my question. I'm sorry, I missed the beginning statement. You were submitting this for who? Who do you?
For the county attorney, for Hillsborough County Attorney, John Coughlin, and Representative Lynn Blankenbecker. She's the one that sent me the information. And I got on the phone with Senator French, and he said to me, why don't you go ahead and file it? We didn't have time to get, you know, other sponsors on there as I was sitting in Florida. And I said, I'd be more than happy to take care of it.
Thank you.
You're welcome, Mr. Representative.
No, go ahead, Representative.
Actually, a question of the chair. Do we have other speakers on this?
We do.
Okay, thank you.
Yeah,
Thank you.
There is a duty expert that's coming up who's a law professor, and it's not that often we agree on things, but I'm sure he'll make a difference.
He'll be up next.
Thank
Thank you, Representative Baldassare. The chair recognizes, if I'm correct, Professor Scherer. Did I get that right? Is it Professor?
Yes, and Commissioner.
Ah, and Commissioner.
Good morning, everyone. My name is Buzz Scher. I'm a newly elected police commissioner in Portsmouth, as well as a law professor at UNH Law. I am speaking in my individual capacity, and my testimony and opinions are not those of either the Portsmouth Police Commission or UNH Law or the university as a whole. I'm in support of HB 1215 for a couple of reasons, and then with, as Representative Baldassare referred to, with one suggestion for the committee that I'll get to. One, I'm in support of it for two reasons. One, the war on drugs has not been successful. It's been operating for 50 years, almost 50 years at this point, at least, and it has become the black hole of government money, be it state money or federal money, and we just keep pouring money into it, and the problem is no better solved now than it was when the war on drugs first started. I think it's an expensive effort that is misguided in the long run in terms of dealing with the essential problem, which is a mental health issue. It's a drug addiction issue, and counties are spending money, municipalities are spending money, states are spending money, the federal government is spending money, and it's just not getting better. The opioid crisis is the best reflection of that. In spite of all the draconian, in some instances, drug laws we have in this state and in the United States, there was an opioid crisis. If the war on drugs was working, we wouldn't have had the opioid crisis. It's a black hole for money, so I think the war on drugs is ineffective. It's expensive, and it's in the end, it's proven to be misguided. The money is better allocated to drug treatment, substance abuse issues, and not the prosecution. I think there's other witnesses who will testify to how much money this bill would save if we're not prosecuting these smaller amounts at the felony level, which is what this bill in part accomplishes. And it also says, if the police find the residue of a drug in a container or on a pipe or something like that, it's just not worth the money to prosecute that case. And I would point out that the real impetus behind this bill is a county attorney, the Hillsborough County Attorney. My guess, I haven't talked with County Attorney Coughlin, but my guess is he would say, and I will talk to him, but he would say, we just got to stop wasting our money on these kind of prosecutions. I would suggest, and I will draft something and submit it to several members of the committee. I would suggest that it may well make sense to make an exception for fentanyl. I think amounts of fentanyl under 1 gram can still have a devastating effect, and so I think there's relatively simple language that can be drafted to carve out fentanyl of less than 1 gram in the residual amount definition. With that, I'm more than willing to take questions.
I don't see any, I'm going to recognize myself for a question. Um, So this law, it proposes to change the possession of all controlled substances over a gram, if I'm reading this right, to a Class A misdemeanor.
Correct.
So, in other words, if I were to be found with a kilogram of cocaine, would this not apply?
It would apply, but if you're found with a kilo of cocaine, you would be prosecuted in the first instance. It's very, very likely you would be prosecuted by the U.S. Attorney for possession with intent to sell at the federal level. And even if not, which would be rare, but even if it wasn't prosecuted at the federal level, you would be prosecuted with possession with intent to sell. You know, you can't make an argument that possession of a kilo of cocaine is a simple possessory amount, and you would, without question, be prosecuted either in state or federal court for possession with intent to sell. I would point out to the chair that this committee is going to hear a bill this afternoon, HB 1232, which overlaps with this bill. It also accomplishes reducing the possessory amount of a controlled drug to a misdemeanor. It has more nuance or complication, depending on one's view. It has more nuance or complication in that it makes a second possession of a small amount of a controlled substance a felony at the discretion of the judge. So, you know, and HB 1232 also deals with it abolishes mandatory sentencing for drug kingpins. On the theory, I'm not going to be here this afternoon, so I'll just say this now. On the theory that drug kingpins are virtually always prosecuted at the federal level. They're just never prosecuted at the state level. So this is wasted legislation. The wasted bill, wasted statute that's currently in effect. It's not needed, and it's always handled in the Joint State Federal Task Force. It's always handled at the federal level. By contrast, the federal government rarely prosecutes possessory amounts.
All right. Any questions? Oh, go ahead, Representative Lang.
Again, I'm going to ask you to put your law professor hat on, answer this question. So again, doesn't the prosecutor already have the discretion to reduce a misdemeanor down to a violation is one question. And then the second question is, in the definition of misdemeanor here, because it doesn't specify A or B, where an A would have jail time, a B has no jail time, fine only, doesn't this just do the same thing? It's going to be a B misdemeanor, and it's going to be again, the prosecution has the choice or the discretion to negotiate a lower fee or a lower sentence.
Two answers. Since I'm a law professor, I get to give two answers. Answer number one, this 1215 specifically says a misdemeanor. So it doesn't give the prosecution.
It says a misdemeanor, not capital A.
It says, however, a person shall be guilty of a Class A misdemeanor if the amount is on the last bold section of the proposed legislation.
I apologize. I wasn't clear. I meant under current law. It just says a misdemeanor, not a Class A misdemeanor, and that would be by definition under our penalty statute, that would be a B misdemeanor because it's not defined, which has no jail time involved anyway.
I think it's noteworthy that the county attorney for our largest county wants this legislation. He has the discretion, but what it does is it clogs up the system with these small cases, these small possession cases, and it involves a lot more work for their office. And I think, as most on this committee know, the Hillsborough County Attorney's Office and any other number of county attorney's office are overwhelmed with cases at this point, and that they can get rid of these at the front end in a circumstance where they may well exercise that discretion anyway is a positive thing. Again, understanding it's a proposal effectively coming from the Hillsborough County Attorney's Office. So yes, the answer is they have the discretion, but they just as soon screen it out in a more summary fashion in this way.
Representative Conley?
Thank you, Mr. Chairman, and thank you for taking the question. Can you explain the significance of 1 gram and why it's not 7 grams or 43 grams? What is 1 gram, and why is that the number that was used in this bill?
1 gram captures, very often it captures an amount that is, has little effect. Number 2, 1 gram captures a possessory, a personal possession amount, a personal use amount. It doesn't capture a drug dealer of any sort. Even those lower tier drug dealers who are, selling marijuana, it doesn't. The less than or 1 gram, well, less than 1 gram, captures an amount that is essentially possessory.
Representative Conley?
Excuse me, personal possession.
Thank you for that clarification. So this is essentially about personal use,
Yep.
A quantity that somebody might be caught with. Is that, how is that typically prosecuted? Are these plea deals? Is somebody going to jail? Are these being just tossed out because they don't have the time? Could you provide some context on that, please?
Yeah, particularly, there's an overlap here with felonies first. A case that a circumstance or a practice of the Superior Court that tends to funnels all felonies to the county attorney level. Possession of cocaine less than a gram or a gram or above, put aside the large amounts of cocaine, is in the first instance prosecuted as a felony and prosecuted in Superior Court. So it's a tremendous burden on the county attorney's offices. Number 1. Number 2, you end up having a lot of people, 18, 19, 20, 21, acquiring felony convictions which will be their only intersection with the criminal justice system, but it will have a profound effect on their ability to get a student loan, their ability to get housing, their ability to get into schools, it too often, because of the overwhelming caseload of county attorneys in terms of drug cases, this is a felony, just plead to the felony, we'll give you a no-time sentence, and it's a process that too often results in young people who are otherwise going to be unengaged in the criminal justice system acquiring a felony conviction that has legs throughout their life.
Representative Lang?
Thanks, sir. So again, if I read the statute right, and again, I'm going to ask you for your interpretation, is this is going to apply to all drugs,
All
not
controlled drugs.
all controlled drugs. And we're talking about drugs like fentanyl, which less than a gram has the likelihood of killing you. How does that play into this legislation?
That's what I'm referring to when I refer to an amendment that I will help draft for some member of the committee that makes an exception for fentanyl.
Representative True?
Thank you, Mr. Chair, and thank you for taking my question. I'm trying to sort out the 2 different changes in the bill. Referring to the small amount, less than a gram. I understand what that is. You've got a marijuana pipe, and you've got some, I forget what, THC in the bottom, and we're not going to bother people. We're not going to clog the courts with that. I don't understand the second part. However, a person shall be guilty of a Class A misdemeanor if the amount of the controlled substance is 1 gram or more. So personal possession amount of cocaine, I have no idea what that amount is, but
Depends on the drug.
Representative Chu, is there a question?
yes. So how is that going to not clog up the courts if it's still going to be, if it's going to be a Class A misdemeanor for personal possession of cocaine?
It will, the case will go not to Superior Court because it's not a felony. It'll go to district court. And there's a lot more flexibility in dealing with cases.
Thank you.
Thank you for your testimony.
You're welcome.
At this time, the chair recognizes Lieutenant Bill Bright.
Good morning once again. My name is Lieutenant Bill Bright with the New Hampshire State Police, overseeing the Narcotics and Investigations Unit. My testimony is one of information only. There's a lot of talk in here about more or less than 1 gram. And as was noted, with the category of opioid drugs, that's an extremely dangerous dose. Anything for fentanyl specifically, we look at a gram could potentially be 10 fatal doses of fentanyl. And if you get into carfentanil, that's basically the size of half the size of a grain of salt. For heroin, that would be the size of a sesame seed, just to put things into perspective for opioids and how that would be affected by the bill as it is written here.
Thank you for your testimony.
Thank you.
At this time, the chair recognizes David, is it Rothstein?
Good morning. Thank you for recognizing me, Mr. Chairman, members of the committee. So I am one of the directors of the state's public defender program. As the chair and the committee know, we represent the lion's share of the folks that this bill would affect. And I am testifying in support of the bill, and I'd like to make 3 points before I hopefully take some questions. First, the bill would reduce caseloads and workloads not only within our public defender program, but system-wide in terms of the criminal justice system. Second, it would allow law enforcement to focus on drugs as a criminal enterprise rather than a public health issue. And third, it would allow the state to focus on treatment options and the delivery of services for what is often a public health issue rather than a criminal matter. So first, in terms of the reduction in caseloads, and we heard from Representative Baldessaro, he reported information from the Hillsborough County Attorney's Office about their caseloads, and I think that has been publicized. I remember reading an article in the Union Leader where the Hillsborough County Attorney himself was talking about the overwhelming caseload that his office has. We are no different at the New Hampshire Public Defender. I'm going to give you some numbers about New Hampshire Public Defender cases because I think they're interesting and instructive. I think I can safely say that this bill would not only reduce caseloads in the New Hampshire Public Defender, but it would reduce caseloads on contract attorneys who take our overflow cases, county attorneys, as we've heard, the courts, the police, and the New Hampshire State Lab, I think, would all see the impact of this bill. So I looked at our numbers for 2019, which was our last normal year, our last full pre-pandemic year, hard to believe. In that year, we opened up a total of 2,202 felonies that were possession of fentanyl, possession of heroin or a drug that I think this committee knows has become quite prevalent in this state. So that was 2,200 felonies that we opened in 2019. That was 28%, or over 1/4 of all of the felony cases that we opened. And I looked at 2021. The numbers in 2021 were lower because 2021 was our pandemic year still, and everything was slower. But it was still the same percentage. It was 27.8% of our caseload. So this is a pretty consistent figure, that 28% of our cases are simple possession of the drugs that I've mentioned. I also looked at the numbers for the more serious drug offenses. And what I'm talking about there is possession with intent to sell. For example, the kilo of cocaine. Somebody with a kilo of cocaine would be charged with possession with intent to sell that cocaine. And also sale of a drug. And sale of a drug would be treated differently, would not be touched by this bill. It's a more serious criminal enterprise. So in 2019, we opened a total of 194 possession with intent cases dealing with those drugs that I mentioned. And we opened a total of 220 sale cases involving the drugs that I mentioned. So about 414 total cases during that year were possession with intent cases and sale cases, about that universe of drugs. So if you break that down, looking at the numbers, we handle 10 times more simple possession cases than we do possession with intent cases. We handle 10 times more simple possession cases than we do sale cases. We handle 5 times more simple possession cases than we do the combined possession with intent and sale cases. And if you look at a felony attorney in the New Hampshire Public Defender, let's say that that man or that woman, that felony attorney, has 30 felonies on their caseload, which is probably a pretty reasonable number for someone to have. 8 or 9 of those cases at all times would be the simple possession cases, so more than 1/4 of that person's cases. So to look at it another way, again, just talking about these simple possession cases, we figure the average felony from start to finish takes about 15 hours of attorney time to resolve. So if you add all that up, that means that in 2019, we spent $33,000. And again, as has been referred to, these are quantities that are either residue or they involve what is typically a user quantity of the drug. And in terms of how they are ultimately prosecuted in response to one question, they're taking a long time to get through the system, and they are typically ultimately prosecuted with a felony conviction with little or no jail time and with little or no treatment. So you have to wonder what all that time and effort is really going into to keep this a felony. So under this bill, House Bill 1215, if it's adopted, public defenders, contract attorneys, the county attorney's office, and the Superior Court are never going to see cases that are under a gram, which is a lot of cases. A lot of cases are residue or under 1 gram typically. It would take a little bit of time and a little bit of study to determine exactly how many cases would be filtered out, but maybe 25 to 50% of the cases would be a gram or less. The police would issue citations for these offenses. Probably the police would not have to go to court in many of these cases. The lab, which also has talked about a significant backlog in testing drugs, would not have to test the drugs in these cases where they do now. So the other case, misdemeanors, as has been discussed by Professor Schur, they resolve a lot more quickly. Typically, an attorney spends 5 instead of 15 hours on a misdemeanor case from start to finish. They're just less complicated. So even if we get 1,000 misdemeanors per year, that's 5,000 hours of attorney time in our program, as opposed to 33,000 hours of attorney time that we're spending now. Now, I assume, though I don't know, that somebody looked at Oregon when they proposed this legislation, because Oregon has legislation in place that is very similar to this, if not identical to this legislation. According to an article by the Pew Foundation, before Oregon adopted this measure, there were 6,700 arrests for simple possession statewide and about 4,000 convictions for simple possession. Afterward, there were 1,800 arrests and 364 convictions. So there was a significant reduction in the workload on everybody involved in the criminal justice system, from the police all the way. We'd have to do some stuff. and see if that really happens here. The legislature, all of you are well aware of the backlog in the criminal justice system that in part has been visited upon us by the pandemic, making cases much, much harder to resolve for everybody. If we had something like this, even for a year, to revisit it in a year, it would be worthwhile, it would have a significant impact in terms of caseload and workload. Second point, drug crime, the enterprise of drug criminal activity. We are well familiar at this point with the concept of addiction being a medical concept, being substance use disorder, being every bit as much of a medical issue as alcoholism or other things that we're maybe more familiar with before we even heard of fentanyl. If this bill is enacted, you are not sending a message that these drugs are okay by any stretch. You are distinguishing between people who have an addiction, who have a user quantity of the drug, who have a medical issue, and people who are engaging in the enterprise of criminal activity. For example, the person who's got the kilo of cocaine, the person who has drugs packaged for sale or who is selling the drugs. So if this bill goes into effect, we still have a lot of laws, state and federal, to combat the enterprise of drug activity. We have the crime of possession with intent to sell that I'd be glad to talk about if people have any questions. We have the crime of sale. We have the crime of drug sale with death resulting, which obviously this would not be affected by. We have conspiracy laws that also apply. If it's a gram, even as small as a gram of fentanyl, there is still the possibility that that drug is packaged for sale, or that the police have other intelligence that this person who maybe only has a gram is actually a dealer or is actually engaging in a conspiracy. So even if it's a relatively small amount, a gram or a bit over a gram, a person can still be charged with sale or possession with intent. But the practical reality is that when you're talking about a very low quantity of a drug, you generally have somebody who is using it because they're in the grips of an addiction. Also, the police obviously can still make an arrest of a person if they are driving either under the influence of one of these drugs or if they are in active withdrawal from one of these drugs. The law has recognized that. Again, looking at Oregon based on the articles that I've read, Oregon has not noted so far, even though the legislation is new, they have not noted so far a substantial increase in crime, drug-related crime, or people just deciding, well, now that this has been, the penalty's been taken down, why don't I just go out and try some fentanyl? They're not discovering that that is happening, and that's typically not the way that someone just decides, oh, I'm just going to go use some fentanyl. These are typically people using the drug who are sick and who need help and need treatment. So there is a decent chance, and while it would need more study, there is a decent chance that this can be done without a substantial increase in crime or threat to public safety. And then finally, the focus on treatment. In Oregon, just as here, a very substantial substance use disorder population in that state, just as we have here. And as here in Oregon, they found it very difficult to deliver effective treatment. The criminal justice system was just not the place to deliver treatment for this. This system isn't doing it either, I can tell you. There is a drug court here, but it's only a very small sliver of the people that enter the criminal justice system who are eligible for drug court. Most other people are being recycled in this system and are not being helped. They're getting felony time, they're getting suspended time and probation. It's taking longer, but they're not getting help. And this would allow the introduction of more funds into resources for people who are afflicted with substance use disorder. So I would speak in support of the bill. I'd be glad to take any questions that people have.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. What impact do you think that if this were to pass, would there be on the existing incarcerated population who are incarcerated for something that would then no longer be worthy of incarceration? Do you see a mass movement of motions to have those cases dismissed? What do you see the impact of that potentially being?
Well, there's a couple questions there, Representative Roy. First of all, I guess would be the potential retroactive impact of this bill, and as I'm sure you know, most bills are not retroactive, they're prospective, so the legislature would have control over that. There may be some people who might try to make arguments that it applies retroactively, but those are generally not successful. So if that's a concern, that there would be a flood of people coming in and saying, well, now it should be a misdemeanor. We experienced some of this when the legislature changed the penalties for sexual assault to a misdemeanor in some cases, and people were not successful at getting retroactive application of that, because I don't believe it was the intent of the legislature. In terms of present numbers, there are a number of people who are held pretrial. There are still a number of people who are sentenced due to possession-related crimes, simple possession-related crimes. I do believe that it would reduce the burden on the county population. The state prison, there are so many people up there who need the focus program at the state prison. The waiting list is much, much longer than they can afford. It would allow services to be delivered if not as many people went to state prison because of a simple possession case. If there were other options in the community, which, as wonderful a state as we are, which we do lack at the present.
Thank you.
Thank you. Oh.
We're running way behind schedule. Chair now recognizes Ian Freeman.
Hello again. Just want to quickly speak in favor of this bill. I support harm reduction. People are not always addicts when they get arrested for possession of whatever substance we're talking about. It may simply be someone who is able to use the drug responsibly, as many of us do with alcohol. And yet, they're being saddled with felony convictions, and their lives are being ruined. So that needs to change, and this bill does a good job of moving that in the right direction. My only quibbles with it is that I would like to see the amount raised as far as what is considered a residual substance. I don't think that would really be a big deal, because I really don't want to see people hit with a Class A misdemeanor either, just for small possession. So it would be nice to see either the misdemeanor reduced to just misdemeanor, that way it could be charged as a Class B if necessary, and raise the amount for residual amount. That's all I have. Thank you.
Thank you for your testimony. All right. There being no more pink cards on this, we're going to go ahead and close the hearing on this bill. And we're going to take a 5-minute recess. Where did he go? Because the next bill's mine. Yeah.
At this time, we will now open the public hearing on HB 1361. Representative Roy, the floor is yours once you find the bill. Is this for Representative Roy to complete? Friendly reminder to Representative Roy to complete the pink card after your testimony. Well, he may not. We got to see if he's in support of his own bill.
Thank you, Mr. Chairman. I am here presenting for the committee's consideration House Bill 1361, establishing a penalty for any person who transports controlled drugs into New Hampshire with the intent to distribute. As we are all aware, the vast majority, if not all, of the controlled substances that are contributing to our opioid problems and other problems do not originate within the borders of the state of New Hampshire. This alone caused me to do some research on how we could possibly stem the tide of drugs coming into New Hampshire and discourage the importation of drugs. So I looked to other states, and I found that such conservative bastions as California have a similar drug law that makes it a felony to import drugs into the state of California. Texas, there were roughly, I think, over a dozen that had laws similar to this that made the importation of drugs into the state a separate and distinct crime that was more severe. In introducing this law, I believe that it will discourage people from driving across the border with distributable amounts of drugs. It makes their vehicle subject to forfeiture. That's going to make people that are letting other people use their car or having them drive them in their car think twice about coming to the state and bringing drugs into the state. It's a very simple bill, and that's really it. I hope that you'll support it, and I'm open to questions.
Representative Bolden, you are recognized.
Thanks for taking my question. I saw in the bill that you want to carve out 2 ounces or less of cannabis or any cannabis not exceeding the amount permitted in RSA 126X. That seems to be 2 ounces. And I Googled it, and I guess the limit in Maine is 2.5. And I guess I'm just curious if...
Is there a question?
Yes. I'm curious if you know more than I do, because I'm concerned that someone might go to Maine, purchase something legally, cross the border, not realizing that they're facing a felony. And I want to know if that's been taken into consideration. I only Googled it quickly.
I most certainly probably do not know more than you, but I can tell you I based this what was legal in New Hampshire. I didn't consider what others, because if someone, it's my understanding that 2 ounces is the legal limit in New Hampshire. So if somebody went across the border and bought 2.5 ounces, they'd be in violation of the New Hampshire law as it was. So I didn't really consider what is legal in other states, just what it would be illegal to possess in New Hampshire. And with the intent to distribute, obviously we would be exceeding that legal limit. So I didn't really consider what Maine may or may not have, but it may be worthy of looking into it further. Thank you.
Just an observation, considering Representative Roy is a member of the committee, we could have this healthy discussion in an executive session. But Representative Newman, I'll recognize you for a question.
It's a quick question. So what you were just discussing in the last paragraph, it says if it packaged with an intent to sell or distribute, I guess it says distribute. That somebody that did have 3 ounces or 2.5 ounces that came in and it was not packaged that way, then they would
they wouldn't be penalized like it says here. Is that correct?
No, I believe that there's a specific, I don't know if it's in statute or if it's in case law where they've described what and what is not intent to distribute. In other words, several things may make something in other words, individually packaged for resale. Simply the amount itself, especially with marijuana, when you start talking about the difference between 2 and 2.5 ounces, I don't think would qualify for the intent to distribute threshold. I was hoping that the state police would have stuck around and we could have asked that question, but they're not here. But it's a good question, but I believe that there's a separate standard for what qualifies for intent to distribute versus personal use, and especially with regards to cannabis. And I specifically put cannabis in here because not only is it been decriminalized, but it's also legal for medicinal purposes. And I want to avoid anyone who's going to get it for medicinal purposes being charged with importation. So I'd be open to any and all amendments that could protect people that are legally possessing it for their medicinal purposes.
Thank you.
Thank you, Representative.
Representative Roy, if I may ask, since we have some cannabis bills coming up very soon, and it was just mentioned, specifically HB 1598, which you're a co-sponsor of the bill with me, would allow for a 4-ounce possession limit of cannabis. Would there be any interest in perhaps expressly excluding cannabis from this proposed bill?
I would not be opposed to excluding cannabis altogether from the bill. Cannabis really isn't our main problem as far as compared to opiates and specifically fentanyl and things of this nature. So with the ever-shifting sands of the cannabis laws, I would not be opposed to that amendment.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. So what is the present law on intent to distribute?
I don't have the statute in front of me, but I know that there are certain amounts, and there's certain case law that discusses how the product is packaged and things of that nature. And it touches on several different statutes, so it would be lengthy. However, I will save the committee some time now and work. I will distribute to the entire committee at some point today the current statutes with regard to intent to distribute, so everyone has it at their fingertips.
Thank you, Representative Roy. This time, we will adjourn the public hearing on HB 1361. If you exclude the cannabis altogether, I would request that amendment today. The next hearing is not noticed till 11:15, so we have some downtime. Representative Pantelakis. It's great to it's great to see you in person. Yeah, we're not we're just sitting here. Like, there's nothing open. My microphone's just on, so everyone can hear me. So we have 58 bills, or 57, it keeps changing. If there is an amendment to any bill that anyone wants to do that we've already heard, I would always recommend that member get on that right away, because otherwise we'll be making special appearances here just to exec bills. If we can get them exec, as you know, if we have downtime, like right now we have downtime, but it's 3 bills, all 3 with potential amendments, so just throwing that out there for future reference. You don't have to raise your hand. We're not in any formal meeting. You don't need to be recognized by me.
Oh, okay.
It's a free country.
All right. If you could just clarify, because I didn't want to waste time, which we could do later, on 1215, which is the one that the county attorney wants to bring, it is increasing from a class, it's a misdemeanor to a class A misdemeanor. So it is increasing the penalty. Is that correct?
I thought it was redefining what a residual amount was and making a residual amount a violation. That's
correct.
No one has to raise their hand. We're not in any form.
Yes,
Sorry,
correct.
I just don't want to step on John.
But
that's all.
anything above 1 ounce, 1 gram, right now is a misdemeanor, and I think the judge can go either way, where this specifies Class A.
So, if I may, so again, one of the reasons, what questions I was going to ask around that discussion was, the unusable amount of conversation, and being a misdemeanor, it's a B misdemeanor, which would be held in district court. It doesn't even have an option to go into Superior Court if you're charged with just residual amount B misdemeanor. So it doesn't even apply to the county attorney, because a B misdemeanor is heard in district court. It's only A misdemeanor, you have a potential for jail time, you can appeal and ask to go to Superior Court and have the case heard in Superior Court. For those that don't know, I was a police prosecutor for 7-8 years, so I dealt with the district court levels and probable cause hearings in district court to go to felony court. So, but the big issue is, the big part of that bill isn't the definition of residual amount. The big part of that bill is over 1 gram being reduced to a misdemeanor. Because you're talking about an ounce of Coke is now going to be a misdemeanor. You're talking about 6 grams of fentanyl, more than enough to kill multiple people, could potentially be defined as personal use and be a misdemeanor. I think we run into a problem when we use that one generic under 1 gram for all drugs. You're scooping a whole lot of felonies that probably should still be felonies and making them all A misdemeanors. So I think that's part of the problem with this bill. It definitely needs an amendment to clean it up. And when you're talking and using that 1 gram definition for every drug out there, every controlled substance.
There's some concern that we are perhaps running a course to the Right to Know Act. I was considering it. I could ask my Democratic friends to leave the room, but I don't want to do that. He asked if do we need to have a notice our discussion.
Well, depending on your notice, you're always, most all of them are open to work sessions and exec sessions at any time. So you could always open a work session and have a discussion on it.
At this time, the chair will open a work session on HB 215. Representative Lang.
So again,
Representative Lang, I appreciate, and Representative Newman, thank you for pointing that out. Hopefully that we can open that retroactive about 5 minutes ago.
So again, that on that bill, John, that you're lowering the felony level to an A misdemeanor on things that are currently drugs, and then but again, on the case of a residual amount under 1 gram, that is already a district court. So the argument that residual amounts are clogging up Superior Court is on its face wrong, because it's by definition in statute, that first sentence says a misdemeanor. And if you go to our penalty section, which I had to look up a couple nights ago, anything that's not defined as an A or a B and just says a misdemeanor, it doesn't have the capital A in front of it, is automatically assumed to be a B misdemeanor.
Well, I guess I understand the.
If it's not defined, when they prosecute it, it's their discretion to make it an A or a B. If it's an A, my understanding, they have the option to file it in circuit court if they want to. They could go straight to Superior Court. That's so some of the, I'm not sure what they're doing in Hillsborough County. If they're going straight to Superior Court, they probably shouldn't be, but they can. So one option, benefit of having that is that if it's an a good deal to work out is to reduce it to a B. That's really, because then you're not going to serve any jail time. So,
Well, so that's an option.
it's always an option if you charge it, if it's if it's in here where it says misdemeanor, you start with if I was prosecuting, I would start with an A, because the plea is, well, in lieu of jail time, this is what we'll offer you. But this makes it a violation so that it reduces all of that for the residual amounts. Because the residual amount under current law, it says it's an unusable amount on a syringe or inside a syringe or on the needle of the syringe, which an unusable amount, I get that, but that's where the whole issue with 1 gram came into play. It was what would make, is there any drugs that can be under 1 gram but still be a usable amount, and it was fentanyl. So when I was speaking with Buzz, I said that's the only issue really I see. If you support this policy, you got to at least emphasize that you shouldn't be able to overdose on a residual amount. So if you possibly can overdose on the drug, if it's under 1 gram, it really shouldn't fall into this. If it's, because the residual amount, I mean, if you had a lot of addicts, they'll put their drugs inside of, the cellophane of a pack of cigarettes. Well, there's going to be a residual amount in there. You can be charged. I mean, that's not on a needle, but I understand. It's not really a usable amount. So really the goal is, what do we want to do with those type of situations? I'm surprised the police are spending their time prosecuting those, but that's their discretion.
And so the other issue, Mr. Jim, if I may, is that an element of the crime is you have to prove it's a controlled drug. So as a violation, a B misdemeanor, an A misdemeanor, it doesn't solve the lab problem, right? You still have to prove it's a controlled drug, which means it still has to go out to be tested if you're going to go forward with it. So again, the lab argument doesn't play. By reducing the penalties, doesn't change the amount in the lab, other than you might get a plea deal early before you submit it to the lab. Other than that. But so again, some of the arguments around the reductions and it'll save the backlog in the labs. Not true. If I charge a violation level offense for an unusable amount, and I send the syringe, or I send the plastic baggie, or I send the spoon they cook their heroin in, and it's an unusable amount, that will still be there.
I've been notified by the clerk that we are only noticed today for a public hearing and the potential for an executive session. It's not noticed for a possession of a work session. Therefore, I would have to now close the work session. Or actually, you know what? I'm not going to admit that it was a work session. But we are going to. Hopefully, they have bad memories. But we'll probably schedule a work session on this the proper way. Hope you guys all like me. Next time, lock the doors. I will say, you're all my co-conspirators, though. We're all going down together. The issue is, if we are not in a caucus and we're all talking about it, there's a right to know request, because it has to be a public hearing. I mean, I feel that the doors are open, but I didn't write that. That's the law in the books. I mean, the doors are unlocked. We're not like saying, oh, no, don't come in. But legally speaking, we need to notice it. So I think Representative Pantelakis is soliciting us to commit a crime here. You're soliciting us to commit a crime. No intent, though. I don't know the answer to that, but we want to err on the side of caution. Because he's hiding in the ceiling. I don't know. Ask him. Yeah, agreed. So we're not opening anything to 11:15, so if anyone needs a break, now's the time.
Hey, Bill. Scott, this is Bill, right? Correct?
Well, I just was listening to it talking.
We're just sitting here. There's no hearing open. You don't have to raise your hand. I could have, and I just don't like to admit I made a mistake in the notice requirement in front of the entire world. No.
Joe, I noticed that I'm not getting a lunch, at least a notice lunch. Are you planning on squeezing lunches in? If, on the days that we don't have time for a lunch, if somebody leaves to go to lunch, who do they contact to get notes and handouts? Yeah, because there's no amount of people that must be here.
Control you, keep them under
I
control.
gotta control my client. He gets the card up there. Hey, I don't know how to put the card. Oh, I know, that's okay.
This time we will call to order the Criminal Justice Public Safety Committee, and we will open the public hearing on HB 1296. This time, the chair will recognize Representative Sylvia to introduce HB 1296.
Good morning, Mr. Chairman and committee members. For the record, I am Representative Mike Sylvia, representing Belknap 6, Town of Belmont. I'm here to introduce HB 1296, a bill which will restore the historically significant presumption of innocence to the people of New Hampshire and beyond. This bill strikes two sentences from RSA 318B:17B, Roman 1C, which has flipped the burden of proof from the state onto the defendant. In the first case, there is established a presumption that property found in proximity to a controlled substance is forfeitable. Beyond turning the presumption of innocence on its head, it also allows an assumption that the controlled substance is illegally possessed. While one could say a seizure of a legally prescribed drug would be quickly overturned, the fact is that in small forfeiture cases, the cost of an attorney would quickly exceed the value of the property seized. In the second sentence, the language being struck shifts the burden of proof from the state being required to prove its case to instead force the defendant to prove his property has been lawfully acquired and held. In the long history of justice in America, it has been the duty of the state to prove that a crime has been committed, and it is assumed that the defendant is innocent unless the state proves otherwise. While it is, in fact, a burden for the prosecution to prove that the law has been violated, it is a burden which has stood for centuries in America, and rightly so. And with that, I would ask that you recommend ought to pass on this bill. And I'd be happy to take any questions.
Representative Testament, you're recognized.
Thank you. Thank you for taking my question. Why did you focus on what appears to be the case of possession of drugs? Is this true in any other kind of case?
I think this is probably unique within our statutes, that the presumption has been flipped on its head, where the defendant has to prove that he is innocent. I don't know of any other place in the law that such an occurrence happens.
If I may inquire of a question, if you're in a situation involving drug trafficking, wouldn't a large sum of money be considered potentially evidence of drug trafficking? And I guess my point is, I understand the forfeiture of person's property without being found guilty of a crime yet, but if the personal property, or whether it's money or whatnot, is evidence of the crime, isn't that necessary for the state to prosecute the case? Because if you're found not guilty, I presume you get your money back.
So indeed, I believe it is the duty of the state to prove that money and drugs are connected in some fashion. To just assume it, that's fine, but the state should be carry the burden to prove that that is in fact the case.
If I may ask for a follow-up, if a person is charged with a drug trafficking and they're found not guilty, wouldn't their property or money be returned to them?
Yes, it would be, but what this line does is turn the presumption onto the defendant. So instead of the state having to prove its case, the defendant has to prove that he was innocent or that his property was innocently held.
And please correct me if I'm wrong. I guess, because I always read the law that if you are arrested, you can actually be convicted, but still actually get the money back if you can rebut the presumption that that money was not used in the commission of a crime.
I'm not going to argue with an attorney because I know you're right in the way you said it, but the presumption due to these two lines becomes assumed, and the defendant has to make a case that his property was legally held. In all other aspects of law, it is the state that has to prove with clear and convincing evidence that the crime has been committed.
Thank you. Representative Lang?
Thank you. Thank you, Representative, for taking my question. So I guess I'm not sure of your answer in what you said. So do you think after the state's proven the burden of guilt in a drug distribution charge, or intent to sell charge, that they then have to, and you're convicted in court, do you think it's then the state's responsibility to then again go back and have to litigate that to see if you get your money back? Or do you think the presumption of guilt, the guilt that was done in court, proven in court, is enough to flip the argument and make the defendant prove that the money's not drug related?
As I understand it, and once again, I'm not an attorney, what these two lines do is force the defendant to prove that he is innocent. This is contrary to longstanding law for centuries in this country.
Can I have a follow-up for that? Because I think there's an answer in here.
You may follow up.
Thank you. So if we left that sentence in there, or left that whole sentence in there and just added after the controlled substance line, upon a guilty verdict, would that clean up the statute to a way that you would be comfortable, that shows that if you're guilty, then if you're found guilty in court of the drug crime, then you're going to lose your money. But if you have the right to abut the state and try to get it back.
So once again, and I guess I can't really change my answer to communicate what I'm trying to say. These words in this particular statute say presumed to be forfeitable, and then the claimant shall bear the burden of rebutting this presumption. These flip normal law on its head. It makes the assumption that the person is guilty or the property is illegally held. I do have an attorney from the Institute for Justice who may be able to put this into better words than I apparently am able.
Representative Newman?
Yeah, I have some confusion over this also. The sentence that you,
And simply are turning the presumption upon the defendant.
Go ahead with the follow-up.
just make a
Yeah, go ahead.
follow-up that was just pointed out to me, that in the previous part of the bill, there is a wording about forfeiture at the top that talks about that. Thank you.
I'm going to recognize myself for a quick question. I like to, when I look at statutes like this, I like to actually put a real-world scenario to it, if I could. So let's assume the police execute a search warrant. They come into a house, they find 50 grams of heroin prepackaged for sale, and they find $15,000 in the house at the same time. It's not your intention that they should not be able to seize that money at that point, is it?
You are correct, that the seizure is absolutely valid.
And giving myself a follow-up, your intent is that if they are found not guilty, the money should automatically be returned to them. They should not have to go again and prove that that money was theirs legally.
I think what I'm trying to get at is that the prosecution should take the evidence which has been collected by law enforcement and prove that indeed the money and the drugs are connected without presuming that the defendant is guilty. It's always been innocent until proven guilty, and these lines flip that on its head. So I'm looking to eliminate that presumption so that we get back to the presumption of innocence.
Thank you.
Representative Conley?
Thank you, Mr. Chairman, and thank you, Representative. What is the standard that is used to determine in either case? Is it a beyond a reasonable doubt? Is it a preponderance as to whether or not I think you understand the question.
Yeah, so in criminal trials, it's clear and convincing evidence to find guilt. In forfeitures, it's preponderance of the evidence. So it's a lower standard, and it also, once again, is flipping the burden onto the defendant or the property if it's a in rem process.
Thank you, Representative. At this time, the chair recognizes Joshua Albert. And Mr. Albert, before you begin testifying, we're just going to shuffle our seats down. I'll slide down once. Just bear with us for one moment. David uses that one. And then Representative Bradley and Klein Knight use that one. No, Scott. Yeah. You may begin.
Thank you, Chairman, and thank you to the committee for allowing me to testify here before you today. My name is Joshua Albert. I'm a detective lieutenant with the Nashua, New Hampshire Police Department. I have been in law enforcement for over 20 years, and specifically of that 20 years, around 8 has been directly involved in investigating and enforcing narcotics violations. I am here to testify in opposition of House Bill 1296, and I was asked to testify in opposition on behalf of the New Hampshire Association of the Chiefs of Police. The focus on any bill, and this one in particular, should be how to legally and effectively use the proceeds of forfeited monies or property from drug traffickers in constructive ways. Charities, treatments, drug investigations, law enforcement training, the rising cost of equipment that allows us to solve other crimes. Specifically towards some of the changes listed in the statute, relying on the word knowingly, which remains, and removing the word proximity or presumed. While I realize the burden to shift the burden of proof to the state, however, drug traffickers are smart, they're clever, and they are constantly adapting to the ways that we enforce the laws. My fear in removing words like proximity or presumed is that with a simple 1 or 2 levels of insulation, it allows them to retain their money and law enforcement to not forfeit it. I think the focus should never be to help the distributors of poison protect their profits, however, allow law enforcement to use those for more effective endeavors. I'd like to give you one example that we have recently seen in which drug trafficking organizations are utilizing pill presses to make drugs like opioids and amphetamines look like legitimate prescription drugs. So to use an example that was mentioned earlier, instead of finding 50 grams of an opioid or a fentanyl, we find a cache of pills which to the untrained eye, and even on a simple search of drugs.com, would look like a prescription drug. However, that person doesn't obtain a prescription, they don't have a prescription, and a stack of money right next to it. Or even in the other room for that matter, if we're talking about proximity. I would like you to find this bill an expedient to legislate due to the fact that law enforcement in general, in regards to forfeiture, already carries a high standard of meeting a certain nexus of connecting money, drugs, and other property used in drug trafficking. Be happy to take any questions that you have at this time. That is all I have.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. So with the scenario you just gave, pill press, the ingredients to make the pills, drugs in the other room in a safe, in getting there in the first place, would you not have already applied for and obtained a search warrant and perhaps done a controlled buy out of there several times? Would the money from your controlled buy, where you mark the serial numbers, commingled with that stash of drugs found in the safe, not imply that the entire amount of drugs were used as or were a fruit of a crime, as it were?
As it stands right now, if we can locate commingled funds, then we would, in effect, seize the entirety of the money.
Thank you.
Representative Conley?
Thank you, Mr. Chairman. Thank you, sir. Did I just hear correctly that you would seize potentially illegal funds as well as funds that may have been profits from a legitimate job if they're in the same place?
That is correct.
You recognized for a follow-up?
Thank you. And this is a question I intended to ask, but it's along the same lines. If you're confident in your case, and you're confident that somebody is, in fact, distributing these poisons, what would be the harm in a hearing to prove that before one's property is seized?
So those hearings typically already take place, depending on what level of forfeiture is going on. I think the ask to shift the burden of proof is, from a law enforcement perspective, when that case is complete and it is forwarded to the county attorneys for prosecution, we feel that we have met the nexus to connect that money and those crimes together. I think what I don't want to see is by a defendant simply saying nothing or giving any reason. I recently received an inheritance, and that's how I received this money. There's going to be some type of paper trail there that if those monies were obtained legally, that they would be returned. However, currently, if the defendant cannot show that the money was obtained legally, then it is presumed that that money is forfeitable.
Thank you.
Representative Roy?
Thank you for one more question. On the search warrant, it specifically would say what you shall seize. Does it say you may seize the fruits of a crime, or does it say you shall seize?
So a search warrant, particularly in drug investigations, usually comes with an addendum that drug investigation. As I've said, I've been involved in narcotics investigations for a long time, and what we have found in search warrants when we're receiving them back is that certain language will be struck if it is not relevant by the judge before returning that search warrant. Of course, if we enter a property legally on the authority of the search warrant and, for example, find a gun that we did not know was there but we believe was also used as part of this crime, we would stop the search, amend the search warrant, and once it was signed off, then we would collect that as evidence. So in regards to specific monies, we are always, if we have controlled buys into the location, money would be something that we would look for.
Representative Roy, recognized for a follow-up.
I guess what I'm asking is, do you have the discretion, once you have a search warrant is kind of like an order from the court to conduct a search and seizure, do you have the discretion to find drugs and then see money and say, well, I'm not going to take the money? Does the search warrant not direct you to confiscate that as a fruit of a crime?
So I've always been a doer, and this isn't really my realm of expertise sitting in front of you, but I'd like to give you a situation that I think better explains. We enter an apartment on a search warrant where a couple lives. The target of the investigation is the male that lives there, and we have nothing in the investigation that would show that the female is in any way connected. The female has a purse on her, has money in it that she claims to be from a legitimate job, and if we've done our due diligence, we know she works at that job. We would not arbitrarily seize her money. But now, that being said, if among the search she had commingled funds, then it would suggest to us that she was more involved than we were led to believe. And in that case, we would seize the money because of the commingled funds. I hope that answers your question.
If I may ask a question.
Please.
In a particularly a drug case where someone is arrested and suppose that there was money seized, what happens to that money if the court were to find that defendant not guilty?
The money would be returned. And so when we seize money, that money is held in a separate account, and the forfeiture process itself goes through the Attorney General's office. There is as I understand, a separate RSA that allows county attorneys to have money forfeited as part of a plea agreement, but we rarely do that, in my experience.
Thank you. Representative Muse?
Yes, thank you for taking my question. One of the things I'm curious about is the potential impact of the passage of this bill on police budgets, especially in larger cities. And something I'm not quite sure of is what percentage of an operating budget or other parts of the budget that are used to fund either equipment or other salaries or other critical processes would actually go away with this bill.
So I will speak from the Nashua Police Department's perspective. My division, other than officers or detectives' salaries or gas, is 100% funded through forfeiture. So the elimination of funds would obviously bring with it a certain detriment to our abilities to enforce narcotics violations. I have about, at any time, 15 to 20 officers or detectives working for me. And in Nashua, give or take, but it costs roughly $100,000 a year to run our division. Last year was a little bit of different. It was quite more expensive because we needed to do some things. But I think, and if you could bear with me for just one moment, I think it's important to note that the forfeiture money itself is not only used for drug investigations. It's used for equipment, it's used for computers, it's used for things and really I have quite a number of things that that money is used for, and so I think that the impact would go far beyond any narcotics enforcement.
Representative Klein Knight?
I'll just project. How much of your budget is from forfeiture money?
The police department's budget in general?
Yes.
So forfeiture is held and it can be used for law enforcement purposes, but it cannot be used to maintain a budget, the annual budget of the police department. That's done through the city of Nashua.
You recognize for a follow-up?
I'm sorry, I'll take another stab at this. Do you know how much police funds you get roughly? How about if it changes every year from last year, how much you specifically receive for your department based off of forfeiture money?
So on the types of investigations that are completed, and from year to year, that number fluctuates by upwards of even $100,000.
Representative Bolden?
Thank you for taking my question. I was just curious, if you can't anticipate the amount, how do you plan the use of it, and how is it factored into, setting the budget? I guess it's just, like if I was setting my budget and I knew I might get some money, but not sure how much, I don't think I could make plans for how to use it. So how does that work, and how does that fold into the idea that the result of passing this legislation would be a budget cut? Thank you.
So I guess to answer your question, I wouldn't necessarily say it's a budget cut because I view the budget as something that the city issues, but our operating expenses come from forfeiture within my division, the narcotics division specifically. And in every year that I've been there, we have been able to maintain our numbers that we continue to operate. I think like anything else, if all of a sudden a tree fell on my house, I would have to find the money from somewhere, and maybe I wouldn't go on vacation that year. I guess that would be an example. So on lower years, we are paying more attention to how much money we are spending for drug investigations, or money that we give out to their computers or their memberships to their law investigative tools.
Thank you, Mr. Chairman. Thank you for answering my question. I'm looking at this paragraph. Paragraph C is only pertaining to currency, coins, securities, and it basically talks about two different kinds. Any that are used, intended to use for recruitment, manufacture, compounding, processing, et cetera, et cetera. And the next sentence says, all monies, coins, currencies, notional instruments, and securities found in proximity. Now, couldn't we make the argument that any securities found in proximity were part of the enterprise? And is that sentence even necessary?
I think that sentence is necessary because of the word proximity. And in parts of my when I originally started, relying on the knowingly and removing the word proximity, I worry that we are allowing potential defendants avenues that on site they can say that those are legitimate funds, and even if they are found in proximity to the drugs, and it takes a tool away from law enforcement. Whereas if down the road those funds are in fact proved to be legitimate, they get returned. But if that defendant does not have an explanation for where that funding came from, there is no paper trail, or we've done our due diligence proving commingled funds, money used during the investigation, we show that based on the preponderance of the evidence that it was in fact drug related. And these things I think are at times very easy to show. Someone with no job, no source of income, no means of obtaining any money, and yet they have large sums of it.
Representative Bourdonnais, you recognized for a follow-up?
Thank you. So it's unclear that it's necessary, but we'll grant you that. But if we look at the last sentences, the claimant of the property will bear the burden of revolting this presumption. So if it appears to me that if this sentence is not there, then the claimant can't necessarily get their property back in that paragraph.
And what's the question to that, sir?
I'm asking if that's a good conclusion or not.
So I think the sticking point on the bill seems to be the burden of proof, and where shall that lie? And from my standpoint, and speaking on law enforcement standpoint, I think that in order for us to seize the money, we've already had to show quite the nexus to a drug investigation. So before we would even seize it, we know it exists. Therefore, we are making that representation that this money is drug related, it is seized. And if that defendant wants to show that it is not drug proceeds, then let them do that.
All right, thank you.
Representative Newman?
Let me repeat what I said because my mic was not on. This is in reference to your last sentence about where there's been an investigation and there is an nexus between whatever the situation is. And the forfeiture. And, but then the defendant in a case where he's being prosecuted by the state has to prove that the state is wrong. And like was in previous testimony said,
Representative Newman, is there a question?
yes, one more sentence. In the previous, I'm talking about the testimony. The testimony previously said that this is the only place that they see. I don't believe that the defendant should have to prove it, and do you agree with that? I guess that's the best way to finish up. Thank you.
Well, being in opposition of the bill, I do believe that the defendant should have to prove it, because I believe law enforcement, by seizing the money, they feel they've met their burden of showing that there is a nexus and that the proceeds were illegally obtained.
Thank you very much.
Thank you. Thank you for your testimony and for taking our questions. This time, the chair is recognizing Dennis, and I do apologize, I can't read the last name, but Dennis from Pittsfield?
That's me. My name is Dennis Corrigan. Thank you. I'm representing myself. I'm a resident of New Hampshire, and I've worked on asset forfeiture legislation for 6 or 7 years. This legislation has been in place since, I think, 2011, and it's required some modifications as time's gone on, and this is what this bill is meant to do. Let me just say that I think there's a potential confusion in how these cases arise. It's not always the case that there is a warrant that's issued or a person who's found guilty at all. Often there's really two separate tracks that the investigation proceeds along. One, to prove that a person is innocent or guilty, and secondarily, to prove that the property involved is innocent or guilty. This could be money, it could be houses, computers, cars, and these are often seized. And then later on, the prosecutor will show that they are, or not, that they are forfeitable. So the property can be adjudged to be guilty independent of whether anyone is found guilty of a crime. One other point I'd just like to make quickly is that we've been hearing about how if a mistake is made and the money has been forfeited incorrectly, that the claimant can get the money back if it's his. The problem with that argument is that many of these forfeitures of money in particular are for relatively small amounts, on the order of $1,000. And when the claimants consider the advisability of seeking to get that money back, they've got to recognize that they're going to have legal costs to take into account to make it questionable as to whether it's worthwhile on a net basis for them to apply for that money back. Those are the two main comments I'd like to make at this point. Thank you.
If I could ask a question.
Please.
So, was it your testimony that there are circumstances where a defendant goes to trial, is found not guilty, but they don't have their money that was seized returned to them?
I'm more thinking of the situation of a roadside stop where there is no warrant issued, where money is seized, and that's the end of the process.
And if I may ask you a follow-up, so you're talking about a circumstance where the money was seized, but the person was never formally charged with the crime?
Correct, correct, right.
And if I may ask this one other follow-up, would there be, do you have any opinion on the idea of if there was any language added in a potential amendment that if an individual is found not guilty or not prosecuted, that any money seized would be returned?
I'm not sure if I understand the question, sorry.
What I was asking is if there was language added to the law that if the person is found not guilty or not ever charged with any crime, any money seized would be returned.
I think that'd be a great improvement, absolutely, right.
Thank you.
Thank you.
Representative Klein Knight?
Thank you, Chair. Thanks for taking my question. I have one and a follow-up. In your years of expertise, how often do you estimate that roadside confiscation of money happens?
It's difficult to know. Certainly in other jurisdictions, we see this happening regularly, but I can't give you numbers or evidence about the particulars of New Hampshire situations.
And Chair, can I ask a follow-up? Can I ask a follow-up?
You recognize for
Thank
follow-up.
you. Would you suggest the use of body-worn cameras on police officers would crack down on activities such as that?
Yeah, I think that would be a reasonable idea.
Representative Panalakis, you recognize.
Are you saying that police officers stop somebody on the side of the road and they take their money, that it's, they don't give it back? Is that what you're saying?
Well, yes, that is what I'm saying, because they need to make an application to get the money back. And I'm saying if it's a small amount, often it's not an economic idea to work that way. The claimant may decide to just let go of any claim on that money because they're not going to net back very much after they've paid a lawyer to help them in that.
Thank you.
Any further questions? Thank you for your testimony
Thank you.
today. The chair recognizes Dan McGuire. The Honorable Dan McGuire.
Thank you very much, Mr. Chairman and members of the committee. For the record, my name is Dan McGuire, and I'm from Epsom. I was a state representative when we started reforming this area of New Hampshire law, maybe 8 years ago or so. And I think, first of all, there's been a number of questions about amounts of money and so on. The next bill you're going to hear is about reporting. And so the people that will testify on that have the current set of reports, and so they can answer questions about how much does Nashua forfeit and so on, things like that. So I would suggest on the next bill you re-ask those questions. This particular bill is fairly simple, and it's just about removing these two sentences from New Hampshire law. And this is consistent with the way we've been improving New Hampshire law on forfeiture over the years. In general, what we've done is switch it from a system where there is what's called civil forfeiture, which just means that there's effectively a case against forfeited property that's a civil case. It doesn't require, it has a lower burden of proof. It only requires preponderance of the evidence, not proof beyond a reasonable doubt. And because it's only a civil case, then indigent defendants are not granted an attorney to help defend themselves and so on. And what we've done over the years is switch over to criminal forfeiture, which means, number one, if property is going to be forfeited under New Hampshire law, then you must have a criminal conviction of the person for an underlying crime first, and then forfeiture of property used in those cases can be forfeited, right? So you can't simply forfeit money without also having a criminal conviction. So this particular bill simply says, it goes along with that by saying, if you're going to forfeit something, you have to prove, like in a criminal case, that this thing was used for the crime, right? That's what the words traceable thereto means in the previous sentence. So whereas current law, the things that are being crossed out here, is sort of the opposite. It's kind of like guilty until proven innocent, right? It says that the presumption is, you prove to me that this property was not used for this crime, right? I mean, I have in my pocket here, I don't know, $200. If this was seized, how do I prove that I didn't get this from selling drugs, right? I mean, I know that I took it out of the ATM, but you know, that could have been other money, right? I mean, how do you prove it? So really, the burden of proof should be on the prosecutor to prove that this car was used to sell drugs, this money came as the result of drugs and so on. That's the normal sort of thing, right? So in general, that's what we've been doing with New Hampshire law, is we're saying, if you're going to be punished by having your property taken, the burden of proof should be on the prosecutor to prove that you committed the crime. Thank you, Mr. Chairman.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony. Why, in your opinion, would the police be so against this when it really is the right thing to do? Is, you know, if I have cash, which I do occasionally, and I get it seized, how do I prove where that cash came from? And I don't do drugs.
Well, yes, thank you for the question, Representative. Just in general, the current system allows police, even under New Hampshire law, I mean, the thing is there's forfeiture under federal law and under New Hampshire law, and that's the subject of another bill that's over in judiciary at the moment. But in general, there are incentives built into the law for forfeiture to take place, because the results of forfeiture are then, a significant part of them are given to police departments, and they're allowed to spend that money sort of off budget on things that they decide that they want to spend on that have not necessarily gone through the budget process. So that's the incentives.
Thank you. I'm going to recognize myself for a question. So when we lay out a crime in the legislature, we have to, or at least we should, put the elements of that crime for the police to prove. So in kind of culling this money away from the crime of the possession with intent, and saying, okay, now police, you've proved that I sell drugs. Now you have to prove the money you found was also related to those drug sales. How would the police go about doing that? Unless they happen to be lucky enough to have some commingled funds in there from a controlled buy, how could law enforcement prove that that money was in fact a fruit of the crime and it should be subject to forfeit?
Yes, thank you for the question, Representative. My understanding is they can do discovery, right? Like in any criminal trial, you can go and get people's wage records, right? You can if they run a business, get the business records, things like that, and they can show that through those records that there's more money here than should be there from legitimate means, right? So I mean, obviously, the easiest way is if they're recording drug buys, they did drug buys, all that sort of stuff. But even absent that, through normal criminal procedures, you can investigate, right? And you can get records and show things that way.
And I'm gonna, just a follow-up. And what would the threshold be? I mean, to convict someone of the drug dealing crime has to be beyond a reasonable doubt. What would the threshold be to prove that the drugs were in fact related to
The
the crime?
cash.
Yeah.
This is
excuse
about
me.
cash.
Yeah, the cash was related to the underlying offense.
Same thing. Yeah.
So the police would have to prove beyond a reasonable doubt that that money that they seized at the same time as they seized the drugs was in fact ill-gotten through the drug trade.
I think that's true.
Thank you. Any further questions? Yes, Representative Newman.
I'll get used to the mic in a minute here. My understanding as I read this, and I want to say, I'd like you to let me know if I'm correct or not. It says that these monies that are connected to a felonious violation of this chapter. So does that raise the bar of the amount of money that's required to above $1,000? Is that, I think that's what that would mean. I'm not sure though.
I'm sorry, but I don't see.
In C, in line, it's the current law, not the part that's lined out, the current law.
Oh, I see. I see what you're saying.
It would be in
Controlled
line
drug
item.
and felonious violation of this chapter and all proceeds. Yeah, so thank you for the question, Representative, but I think we're starting to get into more detail. I myself am not an attorney, and so I don't think I can answer that. I see the word any monies at the top of this sentence, so I think that's any amount. And one other thing that I do know is sometimes amounts that are seized, and you'll hear that next with the reporting section, are small amounts.
Thank you.
No further questions. Thank you for your testimony.
Thank you, Mr. Chairman.
And the chair recognizes Lee McGrath.
Mr. Chairman, members of the committee, thank you for the opportunity to testify in support of this very, very modest piece of legislation. My name is Lee McGrath. I'm the senior legislative counsel for a public interest law firm called the Institute for Justice. It is a joy to be back here in Concord and talking about simplifying New Hampshire's processes. What I'd like to do today is to demystify some of the dynamics that are in play here and show just how simple and modest this change is. To a legislator's question earlier, I'll just jump to the numbers. Approximately only $300,000 a year is forfeited in New Hampshire and goes into the drug forfeiture fund. So we are talking about a very small amount of money relative to the large budgets that cities like Nashua and other New Hampshire cities have for the important work of law enforcement. But the best way to think about this bill is to think about process and think about what it doesn't do. What this bill does not do is change at all seizures. Seizure is the work of police officers and sheriffs and detectives. It is the taking of property. Seizure is the possession of property. Law enforcement needs to meet a very modest goal, but still a standard of probable cause, as the chairman knows. Nothing in this bill deals with seizure. Doesn't change anything about probable cause, doesn't change the work of police officers and sheriffs and detectives. The next step is criminal conviction. Nothing in this bill changes what happens in criminal court as it relates to convicting a person of a crime. The third step is civil forfeiture. And in this step, this bill changes something modestly. It changes who has the burden to prove, to provide evidence that currency and instruments are related to the fruit of crime, are the fruit of crime. It is a legitimate function of the state of New Hampshire to confiscate the fruit of crime. In a world in which a suspect has been convicted, the next question is, who proves, who has the 51% obligation of preponderance of the evidence to prove that, in fact, that currency was the fruit of crime? In this narrow question, this bill changes from 49 to 51 to 51 to 49. It changes the burden of proof from the property owner who has been convicted already, from the property owner to the prosecutor to prove, in fact, that that money was the fruit of the crime. Now, how does that happen? Today, to make it even simpler, Mr. Chairman, and I'm sure your experience, you know this exactly. How does this happen? In today's world, the property owner must produce the bank statements, the pay stubs, evidence that there was a legitimate source of that $600 or that $2,000. In tomorrow's world in which you pass that, the prosecutor has to file discovery and get those same documents from the property owner, because the prosecutor needs those documents, needs criminal discovery to carry the new post-Sylvia burden of proof. So in reality, this is a very, you can see, I hope, this is a very modest bill as to who does the work initially. In today's law, the property owner provides the work initially. Post-enactment, this bill requires criminal discovery as the first step. In many, Mr. Chairman, members, I hope that's helpful, and I'm happy to answer your questions as to the modesty of this bill and how it is principally driven by the author's conviction of burden, that in our country, the burden, whether it's on the defendant or on the property in civil court, the burden should be on the government.
Representative Burt.
Thank you, Mr. Chairman, and thank you, Mr. Graff, for coming up here. It's always a pleasure seeing you. I tried to look it up. I can't find it on Google. There's a case that was, you know, I just don't know when it was. It could be 4 or 5 years ago. It could be 10 years ago as time flies. A gentleman, I believe, came out of Maine, entered New Hampshire. He had like $10,000, if I remember the case right. And all of a sudden, the police pull him over, see the cash, and they seized it. I occasionally will travel with some cash. What would I have to do if I got stopped and the police saw the cash and seized it and said, you know, I don't know what they would say. Would they have to say that it's drugs, or how would I ever prove where that cash came from?
Mr. Chairman, Representative Byrd, this is a good question because it highlights the difference between what this bill doesn't change and what it does change. everything, the hypothetical or the example that you gave is no different under this bill than current law. The police can seize that 10,000, they can seize your cash in today, tomorrow, because they must have probable cause, a modest standard. They must see that there's some residual drugs in the car. There must be a smell of marijuana. They must have a dog that triggers something. That is all unchanged. You go to trial in New Hampshire, you go to criminal court in New Hampshire, and you get convicted. Then the phase 3 is what happens to that cash in civil court. So in civil court, this is where today you have the burden of showing receipts and bank deposits and pay stubs and things like that. In a post-Sylvia world, the prosecutor has to initiate a criminal discovery. Now, that discovery can include interrogatories, it can questions, it can include requests for documents, and if you don't produce that, you have made the burden of the prosecutor a heck of a lot easier. He can walk into court and he can say, Mr. Byrd has no evidence to show that this was a legitimate source of money. And besides that, we've just convicted him in criminal court for this crime of possession with the intent to distribute.
Thank you.
Any further questions? Representative Newman.
I have my mic on. I'm going to just repeat a question that I had earlier for another witness that I hope I'll say better. How does the amount seized relate to the term felonious violation as it's stated in line 5 of the law? Where it says that it must be a felonious violation of this chapter.
So we're not, Mr. Chairman, Representative Newman, once again, this has nothing to do with seizure. All the police officer, all the detective needs is probable cause. What this has to do with is forfeiture after a conviction. So in New Hampshire, the money must be tied to a conviction in a felony. And this chapter is referring to a felony conviction. Should that conviction happen, then we go back into civil court, and the question becomes who's got to show, who's got to produce, who produces evidence first? Is that helpful?
Just to follow up. Yes, that is helpful, and this is the current law, and it says that. My concern is, how does that relate to, does it make a difference between a small amount like $600 or up to $1,000 and amounts above that? Is there a problem with that this doesn't cover because of the way the current law is written in the paragraph?
Mr. Chairman and Representative Newman, in principle, this law treats $600 the same as it treats $600,000. So there's no change in that. Now, I overheard Mr. Corrigan talk a little bit about the burdens of what happens when the economics of engaging in all this process. So, for example, we know that we don't have this number for New Hampshire, but we know in Connecticut that the median forfeiture is $665. We know in Maine it's $1,700. We know in my state of Minnesota it's $507. And nationwide it's $1,300 is the median forfeiture. And so Mr. Corrigan's testimony is not about burden shifting. His testimony was more about the pragmatic effects of all of this civil litigation on relatively small amounts of forfeiture.
Thank you very much.
If I may, I'm going to indulge myself with a question. So we know when we leave vagaries in the law, what we open ourselves to is judicial writing of a law, if we can. So by taking this away, how, I understand the burden would, preponderance of the evidence, 51%. How would the state then prove, for example, that a large amount of money that were seized in conjunction with a drug forfeiture, a drug seizure case, was actually the fruit of a crime, barring what I brought up earlier, some commingled marked money or something like that? How would they meet their burden?
Mr. Chairman, that's an excellent question, and let me just preface it by one small observation. That remember that the median amount of currency forfeited is $1,300. So now let's move to your hypothetical. A common concern, which is a large, not the 1,300, but the 130,000. The prosecutor will first have to convict that person in criminal court. He will do a heck of a lot of work to achieve that conviction. Then, what evidence did the convicted person produce any evidence that in fact there was a legitimate source of this money? In addition to the type of drug control buys that you spoke of and numbered bills and things like that. So in essence, showing the modesty of this reform, Mr. Chairman, after receiving the discovery request, the property owner really does, in effect, have to prove a legitimate source of this money through the discovery process.
So a defendant could not simply say, the burden's now on you, state, I'm not answering, it's my money and that's all I have to say about it.
Correct, Mr. Chairman. A good prosecutor would say, would ask, show us your W-2. Do you have a W-2? I'd like to introduce it into, I'm sure your defense attorney would like to introduce it into evidence. Your Honor, there's no evidence here.
And since we've shifted that burden away, we would no longer, in other words, he wouldn't be able to just clam up and say, I'm not saying anything, you prove it now.
Mr. Chairman, all right, let me take you into the weeds.
Let's go. Okay.
We're in civil court. Taking the Fifth Amendment in civil court is different from taking the Fifth Amendment in criminal court.
Inference.
In civil court, the trier of fact can infer something negative. So if the property owner, after being convicted in criminal court, finds himself on trial in civil court and he refuses to answer, or even takes the marital privilege, refuses to answer, that can be inferred against him. I apologize for the weeds, Mr. Chairman.
Thank you. There being no further questions, thank you for your testimony.
Mr. Chairman, if I could just,
sure.
if you would indulge me for just 11 seconds more. My search of state statutes reveals that New Hampshire is one of 6 other states that currently has this burden on the property owner in civil litigation. It is, you are in a minority of states.
Duly noted. Thank you. Oh, what? We have one more
I
last-minute
provoked
question. Representative True.
Thank you, Mr. Chair, and thank you for taking my question. And I think I just lost, I don't understand this. This is my first term in criminal justice. Right now, the burden of proof is on the person.
It is.
This law will change it so that the prosecutor has discovery. I'm not sure what discovery is, but the prosecutor will now ask in civil court the person to prove his innocence. And if the person doesn't, so the guy still has to prove his innocence. Yes,
Mr. Chairman, Representative True, despite a lack of experience in the criminal, in this committee, you've nailed it. This is exactly, if it ever did get to trial, the prosecutor would examine the property owner, the person who has been convicted, and he would say, I sent you criminal discovery. You have failed to respond to my criminal discovery. You have produced no records to show that this money is legitimate. What evidence do you now he would never ask an open-ended question like this, but for today, what evidence do you have to show that this is these are legitimate funds? So in effect, at trial, the burden is very different, is very much the same as it is today.
thank you.
Representative Bolden?
Thanks for taking one more question. I'm sorry if you already covered this, but so what I'm starting to understand is that if you want to demonstrate, if you want to demonstrate that the funds are not related to the crime of which you were convicted, but the funds are related to a different crime, maybe gambling or something like that, would you then have to, is that sort of like a Fifth Amendment issue where you're being asked to, provide information that incriminates yourself in order to cooperate? I think, I don't know that I'm phrasing it correctly, but I think you know kind of what I'm asking. Thank you.
Mr. Chairman, Representative Bowling, you have posed an intriguing hypothetical. So, police sees probable cause. Criminal court, the person is convicted of drugs with the intent to a felony level drug crime. We're now back in civil court, and it would be wise if the convicted person wants to try to get back his money, to show a legitimate source for that money and not to show a source that is illegal. And and if the prosecutor would say, didn't this money come from illegal gambling? The criminal defense lawyer would object to that question because it is not relevant to the issue of were the proceeds associated with the drug crime for which the person was convicted. Now the judge still might let it in, but.
Representative Lang?
Thank you, sir, for taking my question. Thank you, Mr. Chair. Just a simple question. Do you think that a conviction of an underlying crime has any bearing on where burden of proof would lie? In other words, I guess in a hypothetical, a conviction of my mind, a conviction of a drug crime, the underlying intent to sell, would put the burden of proof on the defendant to say this is legal. We've already proved beyond a reasonable doubt that you were engaged in drug trafficking, and on a no charge or innocent verdict, the burden of proof should shift over to the state to prove why they should somehow keep this money anyway.
Mr. Chairman, Representative, no. I stand with Representative Sylvia that the state should always have the burden of proof. It should have the burden of proof in the criminal prosecution. It should have the burden of proof in the civil prosecution. Now, to the twist at the end of your question, in New Hampshire, criminal conviction is a prerequisite to the civil forfeiture. It's an expensive prerequisite because it requires going into civil court. It could be handled all to get at the same process as Maine now does. But in New Hampshire, a person must be convicted in criminal court. Should he be acquitted, to Chairman Abbas's question earlier, the money automatically returns to him.
Representative Gathray.
Thank you for taking my question. So what you just said, that if a person is found not guilty, they automatically get the money?
Mr. Chairman, Representative Gantler, yes, they get it back because it is not the fruit of a crime for which the person has been convicted. The legitimacy of this is to confiscate the fruit of crime. It is legitimate for New Hampshire to confiscate the crime should not pay. If a person is acquitted, there's no crime. All the property should be returned.
Follow up.
So, found not guilty, do they still have to go into civil court in order to get that money?
Mr. Chairman, Representative, this is a very important question. In that, there is the possibility, there are not enough cases in New Hampshire to see if this is a problem. It is a problem in other states. In my state of Minnesota, it is a 94% problem. The problem in Minnesota is that I can be acquitted in criminal court, but if I don't engage in this third tranche, this civil litigation, if I don't answer the civil complaint, if I don't show up in civil court, I may have defaulted in civil court. And so the benefit of a conviction prerequisite does not accrue to Minnesotans because so many of them just walk away from their property and don't engage in civil court. We just don't know enough about how this process is playing out. In part, I think it was Representative Bodine's question, in part, one of the reasons we don't know is because this is such a small dollar, a small issue, that it is irrational for every party to litigate all the way through to civil court and civil forfeiture.
Representative Newman, did you have a question? No. I'm going to go ahead. One last question for myself. Where you've seen this law changed similarly to this, have you seen any federal implications? In other words, I foresee IRS involvement in unclaimed taxes from money that was returned.
Mr. Chairman, I have not seen any change in the way in which the federal government the federal government engages in its work on forfeiture. I think the next bill is, no, that was in judiciary. There is another bill that Representative Sylvia has advanced that deals with the issue of New Hampshire's jurisdiction versus federal drug jurisdiction and the connections between the two. The Treasury Department is involved in some federal forfeitures. Mostly it is the DEA and the U.S. Department of Justice. I'd be happy to explore that, explain to you and members outside what Representative Sylvia's other bill does that protects New Hampshire's sovereignty more as it relates to interactions.
Okay, there being no further questions, thank you very much for your testimony.
Thank you, Mr. Chairman.
And he left. Yeah, where'd he go? Oh. Bring your card out. Representative Conley? Ross Conley.
There is a representative
There is
so
indeed.
I got a little confused there. Thank you, Mr. Chairman and members of the committee for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity, and I'm here to voice our support for HB 1296. I'll try to be brief. Just Attorney McGrath covered a large amount of your questions, so just want to give our top line of why we support this bill. It simply corrects language in our drug forfeiture statutes to ensure the burden of proof is on the state and not the defendant. A foundational principle in our legal system is innocent until proven guilty. The state should have to prove the guilt of the defendant. As the law currently stands, an individual who is suspected of a felony drug level crime would have to prove to the state that those assets were innocent of that crime. And we believe it should be the other way around. The state should have to prove the guilt of those assets. And just to be really clear, because there was a lot of questions about this from previous speakers, this bill does not change the way policing is done in New Hampshire whatsoever. Police can go and seize assets at their discretion using probable cause. This has to deal with putting the burden on the prosecutors or county attorneys in order to forfeit that property to the state's possession. So this small change, as Attorney McGrath mentioned, is just a small correction to make sure that we're protecting property rights and due process. And for these reasons, we encourage the committee to move this bill ought to pass. And I'd be happy to take any questions.
Representative Bolden.
Thank you, Mr. Chairman. Thank you for taking my question. I appreciate that you refer to it as a small correction. And I'm curious if you have any commentary on, I mean, you look young, so maybe you weren't there when they set this up in the first place, but would you happen to know anything about the reasoning that went into establishing the law as is? Because a small correction, but years later, makes me wonder what the thinking was at the time and why things went on for so long without any changes. Thank you.
Thank you for the question, Representative. I am young, and maybe not as young as you think, but I was not there when this was originally done, but I can imagine that this would decrease workload for obvious reasons. If the burden of proof is on the defendant, the burden of all the work is on the defendant. So it would obviously make things easier on county attorneys' offices, but that's just speculation. We can just say that the impact of this bill is a real distrust in the criminal justice system. The civil asset forfeiture in general and asset forfeiture are one of the, if you ask, look at polls, YouGov has done polls on this that show that an enormous majority of the country disagrees with civil asset forfeiture, and this ties in with that, where the state must have to prove the guilt of an asset just as they have to prove the guilt of a defendant.
Representative Klein Knight.
Thank you, Chair. I asked this of one of the previous witnesses. Do you think that the use of body cams would solve this issue?
Thank you for the question, Representative. I don't know if it would solve this issue. I think this bill would probably go a long way towards correcting this issue. We did at AFP, we supported the bill from last year, the LEAC Commission that did give funding towards body-worn cameras. We think that's an important tool to hold law enforcement accountable. But we think this little correction of a couple sentences in the law would go a long way towards shifting that burden and correcting the issue.
There being no further questions, thank you for your testimony.
Thank you very much.
The chair recognizes Bill Wright. Is that Deputy Sheriff? Oh, the sheriff. Pardon me. Not my county.
Chair, thank you. Representatives, thank you. I'm Bill Wright. I'm the sheriff of Belknap County. I've been a law enforcement officer here in the state of New Hampshire for over 24 years. I'm in my first term as sheriff. Previous to this, I was the Belknap County Drug Task Force commander. I ran a regional drug task force throughout Belknap County. I'm going to keep this short because I know that the lieutenant from Nashua had covered a lot of the points, but there's a few things that I heard during testimony here that I think you need to hear it from somebody who's done a regional task force and has been boots on the ground when it comes to drug trade. First and foremost, the funds that we're seizing from these people, they're actually drug dealers. They're people who are actually dealing drugs. These are not, there was questions about somebody coming across the border in Maine to New Hampshire and money being seized. Well, sorry, but there's got to be a nexus to the drug trade that is part of that. And that comes in with, it has to be combined facts and circumstances that lead us to believe that. So the next thing is, when it comes to search warrants, I don't want you to be misled that every seizure is based on a search warrant, because that is not true. We seize money when it comes to drug sales, distribution, trafficking, in any other form of drug sales related investigations by contacts that we have, consent searches, car stops that we see things in plain view. Again, it's based on the facts and circumstances that lead us to believe that these proceeds are connected to drug sales, distribution, manufacturing, trafficking, so on and so forth, as listed in the law. The burden of proof as it relates to any of these cases, whether it be a civil forfeiture or conviction on a criminal case, is the burden of the state. So whether it's preponderance of evidence or beyond reasonable doubt, the burden is based on the state. So we do have to prove, and there are processes in place. Now, on open source, which Google or whatever platform that you use, you can look up the New Hampshire AG's drug drug forfeiture and asset processes. So there are processes that we are required to do as law enforcement in order to seize funds or property as it relates to drug related offenses. The burden of proof, again, preponderance of evidence as it relates to a civil case or civil forfeitures, there is a process there. If I seize money based on a drug investigation, and I believe that it has to do with these types of cases where it's drug sales, drug manufacturing, I in return have to do a process. So I have to give a 7-day letter to the defendant and let them know that this is my intent. The burden is on them to file then the paperwork to say that they want to contest that, and that's where we start the process for a hearing for a show of funds sources. Then the burden is on them to bring in a pay stub or whatever they want to say is that's their money. And again, in today's technology world, it's very simple for them to do that. A few things that also were stated, there was talk about convictions and process and all that. There are times where we seize funds from a person, we seize drugs from people, and we know it's in relation to a drug sales case. Not all cases are brought before the courts. And some of those reasons are because maybe somebody became a cooperative source for a larger investigation that's for the betterment of the community, and they never get charged or convicted of the original offense that we were targeting them for. But the proceeds that were taken from them during these investigations, and sometimes substantial. In Belknap County, we've had several cases, over $10,000 in cash for people who have not had a job in several years. So that money is then, we go through the civil process, and that money is forfeited to the state, which depending on, at our state here, 45% goes to the local entity that did the investigation, 45% to the Attorney General's office and 10% to Department of Health and Human Services. So that money is divided up. The burden of proof would be on that person to come in and show the source of funds. And that's a very small burden because I already had to show the burden of why we were taking it in the first place. And we do that through reports and through testimony when it comes to the court process. Striking out this language, if you have a drug dealer that has their drugs located in one location, and then the proceeds are in an outbuilding or perhaps hidden somewhere else within the house, that could be a problem for us to be able to connect the two. Because now it's saying it's not with the drugs, it's not drug money. Well, that we find is untrue, and based on training and experience, we can tell you that it's hidden all over the place. Sometimes we get there, the drugs are in the safe, and the money is just strewn all over the house. I have several photographs on my phone if you really want to see them. So, again, when we start looking at the civil forfeiture part of it, we don't just take money and then they don't get it back unless they prove it. There are processes in place, and it's up to them to do this. And I don't know where the numbers come up there was a gentleman that testified earlier about $300,000 in the state of New Hampshire, what have you. I don't know where those of seizures. I don't know where that source comes up with, where police operate based on evidence. We're evidence and facts type people, so I don't know where that comes from. But if it's such insignificant money as stated previously, then why is it a problem with the way that we've been doing it and the processes that we've been following with the New Hampshire AG's guidance? I'll take questions.
Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question. Could you explain why AFP, Mr. Graff's group, and 45 other states are wrong for bringing this bill forward?
I cannot tell you why they're wrong. I can tell you why it works here in New Hampshire. So you cannot compare even police. You cannot compare how we police here in our state to any other state. So we're very unique to what we do, and we do give money back. I don't know what other states do. I don't police in other states, and I honestly can't answer that.
Follow-up?
Follow-up.
Thank you, Mr. Chairman, and thank you again for taking my follow-up. If my understanding is correct, that you do go through a process to keep that money. So if that's the case, why would this bill hurt that process that's already in place?
Well, as stated previously during testimony, why don't the police just go and ask for the W-2s, or why don't the police ask for, bank statements and all that? So if a person can simply say no, we do not want to infringe on their right to say no. The problem is that when you start looking at getting a search warrant, you're building that based on probable cause to say that that specific dollar bill that we found in this stack of money that was found during a drug raid was in fact money that was used during a drug transaction for this specific thing. I don't think that we could go with a search warrant and actually physically say that that specific $1 bill was specifically used to purchase or manufacture or traffic drugs within that. But as a totality, that money was used in totality to do that type of activity. So a search warrant's very specific.
Thank you.
Any further questions? Oh, yeah, Representative Klein-Knight.
Thank you, Chair. Thank you, Officer, for taking my question. Has this process at all, has anything significantly changed in the last 20 years from doing drug forfeitures?
Yes. So a lot of county attorneys no longer want to go through the criminal process as to utilizing the seizure money that we seized during an event and use that as part of a negotiated plea agreement, because it's been questioned as to whether or not that could have been a payout or payoff to either reduce a charge or it just gives the impression that it's not there. So So as it relates to that, we are not going that route because there is a separate process for the civil portion.
Follow up?
Yes, just one.
Okay, thank Well, with that being said, and you said to go online and look at the Attorney General's asset forfeiture materials, this hasn't been updated since June 26, 2007.
Yes, that's the one that's online. That's the practice that we still do. So between that time, there had to have been enough opportunity for people to challenge our processes between then and now.
Representative,
14, 15 years.
that question would be more appropriate to the Attorney General, I think, who manages that page and not the sheriff. Any further questions for the sheriff?
Thank you for your time.
Thank you, Sheriff. That's it, right? No, that was it. Okay, there being no further witnesses, I'm going to go ahead and close the hearing on this bill. And oh, okay.
At this time, we'll now open the public hearing on House Bill 1493. I apologize to the representative that we were behind schedule. In fairness, it was your bill that.
Thank you, Mr. Chairman. And for the record, Representative Mike Sylvia from Belknap 6, representing Belknap 6, town of Belmont, passing around a sample sheet from the Institute for Justice, taken from their report in Minnesota, which shows a sample of the sort of data they collect related to this bill. So I'm pleased to introduce today HB 1493, a bill which will clarify reporting duties of the Department of Justice as it relates to seizures and forfeitures. Over the years, the legislature has sought to assure that our citizens are protected from unjust property deprivation. One of the keys to understanding whether or not there might be a problem was found to be a lack of reporting. Data which is collected by the department and made available in a report will serve as a useful metric in assuring our citizens of being treated fairly. In 2018, SB 498 was passed by the legislature and signed by the governor. Unfortunately, the reporting which was required has not been provided. This bill seeks to address possible barriers and provide much needed data with minimal burden on the department. As it stands now, there are 2 reporting requirements. This bill consolidates reporting under RSA 617:12 and repeals the report under RSA 318B:17F. I hope this bill will be accepted as an important measure bringing transparency to seizure and forfeiture data. I'd be happy to answer any questions, and remember, the experts are behind me.
Representative Pantelakis?
Thank you for taking my question, but I would like to know what the comparison is of from Minnesota to New Hampshire.
That is a great question. So for years under 318B, the reporting requirement was related to the Drug Asset Forfeiture Fund. And that was an annual or biennial report, which really just listed the amount of the fund, its balance, and how much was put out in grants. It was very minimal and didn't provide any information on specific forfeitures. If one requested from the department, you could get a report that listed forfeitures after they were all complete, so gone through the process and gone through court and finally made official. And that would list perhaps cars or money that were forfeited and what department would have received that forfeiture fund. So the information that we were getting was very minimal and doesn't really help us see what kind of issues might be things that need to be addressed in understanding the scope of the forfeitures and seizures.
Second question. Could you tell me if there was funding to the AG's office to do this reporting?
So the data is assembled already, as I understand it. So the information is available. It's just a matter of putting together the report. And I'm sure Mr. McGrath would be able to provide the information related to some of the other states and what kind of process they go through and have some better ideas of what's involved. But most of this information is available. It's just a matter of assembling it.
The reason I ask that question is that we often tell the AG's office or any department in this New Hampshire that we want things done, but we don't give them the funding for it. So I was wondering if you knew if this was specially funded.
It is not specially funded, and we did not get a fiscal note on this bill, so I don't know if that is a problem. I suppose the AG's office would drop by and let us know about that if that is an issue that they're concerned about.
Thank you.
Thank you, Representative. See no further hands raised.
Thank you.
Is it the next witness will be Dennis, is it Carrigan?
Thank you very much, Mr. Chairman. For the record, my name is Dennis Corrigan. I'm a resident of New Hampshire and I've worked with some of the gentlemen in the room here today for several years on asset forfeiture bills and legislation. And one of the key things that has guided us is the need to access good quality information about the particular seizures and properties forfeited in order to promulgate better approaches to the legislation. It's really a key that if legislatures don't have that information in front of them, it may be difficult to see the importance of any reforms that are proposed. In this bill 1493, it seems to me, I'm not a lawyer, but it seems to me that there are really three separate changes that are being proposed here. The one is to strike the last sentence of 318B 17C, Roman numeral 2, and to replace it with a new section 3. It seems to me that there's, as a layman, not a lot of difference between those two. I'm not going to talk about that change. Similarly, to change the word shall to may is perhaps a term of art for the lawyers to talk about. I really only want to concentrate in my testimony today about the very last element, which is the changing of the words from the to each and from summary data to data. And what guides these changes, proposed changes, is the concept that it's desirable for the public to have access to case-level data so that, for instance, the average can be computed as to what is the amount of forfeitures per case. It's possible that the data that's being presented to us now from the Attorney General does show the data in non-summarized form that is particularly helpful. There is an argument that could be made that not every element in the legislation which prescribes the form of the report is available. In particular, the approximate value and disposition is perhaps properly reported, but I'm not sure the type is shown, whether it's cash or a automobile or these sorts of things. And these details are available in reporting in different jurisdictions. Thank you for your time. I know we're running behind, so I'd just like to indicate willingness to answer any questions, or maybe.
Seeing no hands raised, thank you for your testimony.
Thank you.
This time the chair now recognizes Ross Conley. Representative Muse. Representative Muse? When I close the public hearings, if you don't mind, could you read off the sign-in sheets for members in support or not? We haven't been doing that today. Oh, I'm speaking of Representative Muse. Just a reminder. When people sign in support or opposition to bills, we were supposed to be reading those after every hearing, and through collective negligence, we have not been doing that. It should be there, but we don't have to. You have to do that now. I'm just telling you in case I don't forget.
Thank you, Mr. Chairman and members of the committee for holding this hearing today. Once again, for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity, here to voice our support for HB 1493. This bill is quite simple and modest. It provides more transparency in the use and procurement of forfeitures in New Hampshire. Currently, we have a report that gets sent to the governor, the executive council, and the fiscal committee. It's quite unclear, it's confusing, and it doesn't provide the amount of detail that would better inform legislators and government officials into making decisions about forfeiture in New Hampshire. We often get ranked here in New Hampshire as first in freedom. One of the areas that we certainly are not first in is government transparency, and we view that this bill will certainly help to give more transparency into forfeiture proceedings, answer a lot of these questions that we've been hearing over the past two bills and the other bill in judiciary, and having more, unleashing that veil of government and having more information to the public so that they can be better informed is always a good idea. It builds trust with the public, and we believe just these few changes to the current statute will provide a better look at what is happening with forfeiture in New Hampshire. I'll be brief and just leave time to answer any questions, since Attorney McGrath behind me has a lot more of the individual detail of what's currently in the report and what changes this would make. But the real message is that this provides more transparency and will better inform both the legislature and the public in decision making in the future. And it should not take up an enormous amount more time, since they already have to create a summary of the existing data in current law, so it would probably save them time, if anything, in the Attorney General's office.
Representative Pantelakis.
Thank you, Mr. Chairman. Did you say that there was a report that went to the governor, the executive council?
Yes, so the current statute, if you look at the bill language, that The Attorney General shall report 60 days after the close of each fiscal year to the governor and council and to the fiscal committee of the general court a detailed accounting of the grants provided law enforcement agencies, yada, yada, yada. They have to provide this report to the legislature, governor, and executive council. We just believe that the detail in that report is not clear and can be confusing to read and not detailed in a way that actually gives a look of what is being done correctly and what might be areas of correction in forfeiture proceedings.
Thank you.
The witness is excused.
Thank you very much.
The member of the public is excused. Excuse me. Bad habits. At this time, the chair now recognizes Lee McGrath.
Mr. Chairman, members of the committee, thank you for the opportunity to testify in support of this legislation. Let me answer Representative Poplik. Thank you. In Minnesota, the state attorney, the state auditor is responsible for publishing every year individualized line-by-line forfeitures for every type of asset that has been seized. So all 8,000 forfeitures in Minnesota are reported on a line-by-line, property-by-property basis, and she has allocated a general allocation for the running of her office. When that reporting requirement was implemented in 2009, there was no incremental funding going to her office. She absorbed the costs of that in her budget.
I was just asking the comparison of the state. New Hampshire's very small, Minnesota's very big.
It is.
Thank you.
Mr. Chairman, this is not, once again, if you would indulge me, this is not a burdensome requirement. And if I may, I'd be happy to distribute. I have copies of the last 3 reports. And the Attorney General is reporting on a line-by-line basis.
You may pass them around.
Line-by-line basis. But what this piece of legislation would do would add an element to this reporting. It would add the element of the type of property and the type and the value of that type of property. So you can see that here in the Minnesota report, a 1995 Chevrolet Lumina was sold for was forfeited for $291. So what this bill does is change New Hampshire's reporting from a cash flow system, and you will see in the reports that when this bill was modified in the Senate a few years ago from Representative McGuire's an original bill and turned into a reporting bill in the Senate, it was ambiguous to the type of elements to be reported, and the Attorney General reasonably has interpreted the statute to be a cash flow statement. How much money seized, how much money forfeited, how much money allocated along the state's 45 by 45 by 10 formula. The incremental, the small change would be to add an element about property. Why this is worthy of your consideration. It is worthy of your consideration because in states that report on a property basis, you can see just how modest the forfeiture is in currency. So in Connecticut, once again, Mr. Chairman, the median currency forfeiture is $665. In Maine, it is $1,670. In Minnesota, it is $507. And nationwide, it is $1,300. That information is vital to this committee and other legislators because it shapes the discussions that were raised earlier about the cost of litigation in a civil system where you don't have a public defender, where the indigent don't have a public defender. Secondly, it raises questions about law enforcement's prioritizing. There are certainly reasons to prioritize large criminal activity. That is not in dispute here. Connecticut's 665, knowing that, state legislators in Connecticut may come to a different conclusion. Mr. Chairman, just one other point to this modesty. Representative Sylvia resisted the request of a certain public interest lawyer to adopt 30 reporting elements like the kind that Arizona, Colorado, Maryland, Minnesota, and New Jersey have adopted. And so once again, not 30 requirements, but just a couple of tweaks to the reporting bill is the Sylvia style, and I'm happy to answer any questions you might have about that.
Thank you. And if I just may ask a question, under Roman numeral 4, would it change the language from shall to may in regards to adopting rules? What is the rationale for changing that to may as opposed to shall?
Mr. Chairman, the rationale is that the Attorney General may not have to adopt rules to meet the legislature's requirements. He just may have to just put out an Excel spreadsheet with some instructions. So going through the rulemaking authority, formal rulemaking authority, may not be necessary.
Representative Pratt, you had your hand raised?
Yes, I just have a quick question. All day we've been hearing about the small amount of money that's involved in these, but in my area, I'm familiar with 2 houses that were taken for drug forfeiture.
Yes, sir.
And they were loaded with money, loaded with jewels and diamonds, and they had to dig the backyard up and found even more in vehicles and motorcycles. So it would seem like one of those a year would bring this number up from $200 to $300 to a higher number than this. Now is, go ahead.
Mr. Chairman, Representative, yes, there are the anecdotal large seizures, but the median seizure, the median forfeiture, the median. Now remember, not average, median. Yep. The median forfeiture in New Hampshire is $7,000. So absolutely, law enforcement, crime shouldn't pay. It's legitimate for the state to confiscate the fruit of crime, and there will be some large outliers. So you're absolutely right, Mr. Representative.
Representative Klein Knight.
Thank you, Chair. I have the same similar question to Chairman Abbas on line 14, changing shall to may. Doesn't this make the whole entire bill irrelevant?
Mr. Chairman, Representative, I don't think so. I hope not. I don't think so. I think it's just a question of whether New Hampshire's formal administrative law as it relates to promulgating rules is necessary for the Attorney General to meet the obligations, the renewed obligations that you're putting on him, and so therefore he may not have to go through the extended administrative process of rule promulgation. it does not lessen, it does not reduce his obligation to meet your your data requests.
Thank you. Seeing no further hands raised, I want to thank you for your testimony.
Thank you, Mr. Chairman. Thank you, members.
At this time, we will now adjourn the public hearing on HB 1493.
go to Massachusetts. To buy a joint at a legal store, and this is what it's in. Already rolled. It looks like a fatty. I mean, I wouldn't know. Looks kind of giant. Yeah. I would have thought that would have been something, maybe they filled it up with well, it's a big. That's right. Expiration date, everything, huh? Funny. A weed expires? Or it's best if consumed before, freshness is.
Used by.
It's too old, you gotta burn it.
How much, that's right, that's different.
Alcohol is a preservative. If it's too old, you gotta burn it, right?
All right, so now we're gonna get used to this, I guess. Right, I know I'm not last.
Yeah, I never thought of it. They had a grand opening last. In the house, we still want meeting at the house. So I don't know if it's, I know there was a, down as you go into, the Dianetics.
Yeah, that's what I said, I agree.
I always went to that because they had great soup. You know, there's two choices of soup, they had great soup.
As an intent, this is one of the things we're talking about. I'm a little nervous about this. One of them deals with definitions, one of the definition sections. Paraphernalia. Yeah, and so that impacts a lot more cases, because one of the parts of an intent case is showing all the paraphernalia, right? The plastic baggies, the scales, you know.
We have no trash cans?
Money's an element of that crime as well. So when you show the plastic baggies, when you show the scales, and you show the color, this all together proves he's an intent case. This isn't a guy who just happened to play around. And he's got 4 rows, he's got plastic bags all over the place, you know, and so the accumulation of that is what creates the burden, creates the burden of proof beyond reasonable doubt. It's not just the common, or comments, combination of evidence of consent, right, it's all this other stuff that goes on. So, again, yes. Maybe I'd like to see some more laws, so forfeiture we have like a criminal court process. It depends to make a motion, to be ready to make a motion. We want to return, here's the proof that we own, we have the money. Right? Or the prosecution should say, Your Honor, we will do all evidence taken in the case.
It's never gonna be a zero.
I just highlight that one issue that confidentiality is really important. But Darryl, I'll have to give deal with that confidentiality piece that was ripped out of 17.
So you gotta show that because that's it. You gotta wear a mask, and At this time, we will now, the Criminal Justice Public Safety Committee will come to order, and we will now open the public hearing on House Bill 1232. Representative, thank you for joining us today. We do need you to. Never mind.
Got the pink card there? Yeah, thank you. Mr. Chairman, members of the committee. I was served on the Criminal Justice Committee 2 terms about a decade ago and always enjoyed the discussions here. It's good to be back. I've long been an advocate for fair sentencing and a transparent criminal justice system. Oh, by the way, sorry, Mark Warden, representing Manchester, Ward 8, Hillsborough 15. And said I'm an advocate of a criminal justice system that respects our cultural norms while also protecting individual liberty. This proposed legislation, 1232, is similar to what this committee heard last year. That was HB 615 in 2021. That bill passed the committee and the full House before dying in the Senate. This particular bill has been stripped down. It's much simpler, and right there in the analysis of the bill, it's correct. This bill reduces the penalties and removes mandatory minimum sentences for certain first offense drug offenses. And then on the methodology section, it says the Judicial Council states this bill would reduce first-time possession, transportation, or use of certain controlled drugs from a Class B felony to an unclassified misdemeanor. Subsequent violations, meaning not your first time, could be sentenced as either Class B felonies or an unclassified misdemeanor at the discretion of the prosecutor. And then if I can go through the sections real quick if you'd like. Section 1 reduces the penalty on first-time offenses from a felony B to misdemeanor. If an offender has been convicted previously, then the penalty is reduced from felony A to a felony B or misdemeanor. They'd still give them that discretion. Section 2, the first paragraph removes the requirement for mandatory minimum sentences of, this is regarding selling near a school. The second paragraph relates to drug enterprise leaders and removes the 25-year mandatory minimum sentence, leaving the sentence up to the court. And then section 3 is super simple. It repeals penalties for Schedule 5 controlled drugs. And according to the DEA.gov website, Schedule 5 drugs are defined as drugs with lower potential for abuse than Schedule 4 and consist of preparations containing limited quantities of certain narcotics. Schedule 5 drugs are generally used for antidiarrheal, antitussive, and analgesic purposes. Some examples are cough preparations with less than 200 milligrams of codeine per 1,000 milliliters, such as Robitussin AC, Lomotil, Motofen, and Lyrica. So the main goal here is to reduce penalties for first-time offenders with a goal of reducing the backlog and the clogged criminal justice system and the courts, and keeping people who are guilty of victimless crimes from potentially having their livelihood ruined and opportunities denied because of a conviction. This topic was brought to my attention by an assistant county attorney in Hillsborough County who said she was tired of seeing so many people's lives ruined. She thought that her office should have more discretion in prosecution. She was particularly interested in changing the law to allow for possession of personal use levels of fentanyl and heroin. And as bad as those things can be, as bad as those substances can be, they are pervasive, and running these people through the criminal justice system often exacerbates the problem. She wanted the option of putting them into a treatment program instead of throwing the book at them, but she felt they lacked much discretion in the prosecutor's office. She said they're just overwhelmed with so many cases. And while this bill isn't exactly what she's looking for, it is tangential and was the impetus for this proposed legislation we have today. With that, I'll be happy to answer questions best I can, and I don't know if there's somebody else testifying or not, but thank you for your attention.
if I may ask, when it says drug enterprise leader, what would you consider that or define that to be?
I consider it a drug dealer, somebody who's and has a lot of product in possession, and I did read through the definitions, and that's sort of my interpretation of the definitions in the statute.
Representative Burt.
Thank you, Mr. Chairman, and thank you, Representative, for your testimony. You said that it died in the Senate. Was the issues with the Senate addressed, or is it?
We're not supposed to refer to the other body.
I thought that was just on the House floor.
I believe it applies in the committee room as well.
Really? I've
Just
only been
refer-
here 12 years, I guess.
Oh, thank you for the
That's
question.
it.
I really don't know the answer. I'm not sure what happened in the other place.
All right.
It wasn't my bill last year. I wasn't following it very closely.
Okay, thank you.
Thank you,
Yeah.
Representative Burt.
Seeing no hands raised, I want to thank you for your testimony.
Thank you.
Representative Conley, excuse me, the chair now recognizes Ross Conley.
Thought I had been promoted for the second.
I haven't had lunch today, so bear with me.
I'm with you. Thank you, Mr. Chair, members of the committee. For the last time today, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity, here to voice our support for HB 1232. As Representative Warden mentioned, this is a bill very closely similar to HB 615, which passed this committee last year and passed on a voice vote out of the House. It does simplify the language where last year's bill addressed a lot of mandatory maximums, a lot of fines, reduction of fines across the criminal code. This bill tries to find some consensus for that other body where we're focusing specifically on those first-time drug offenses. We view the current situation where we've kind of reverted back, unfortunately. The drug dependence is a pretty personal problem for many Granite Staters. Almost everyone has a connection to somebody that has had an issue, especially in my generation, with dependence on drugs. And over the past couple of years, we've unfortunately gone back on that, where we're hitting very high overdose rates once again. And obviously, the current trajectory is not working. And taking a new approach is what we believe is needed, where we take first-time drug possession, especially as a misdemeanor, and try to direct those addicts towards getting the help they need. And that help is not in prison. It is in treatment facilities, so that they, especially 90-day treatment facilities, which will help them get out of the cycle of dependence on drugs. Sending them to prison only creates a cycle where the famous George Jung quote that he went to prison with a bachelor's in marijuana and he graduated with a master's in cocaine. I think that the solution is not in prison. The solution is in treatment and getting these folks the help they need. And we believe this bill does just that. Just to answer some of the previous, in terms of Section 5, that does apply to drug dealers. However, that just removes a mandatory minimum that's included currently. So it gives more discretion to the judge to make a sentencing decision based on the level of crime. We don't believe that one size fits all is the best approach towards addressing the criminal code. So allowing that judge more discretion over that, we believe is appropriate. And with that, I'd be happy to take any questions.
Representative Burt.
Thank you, Mr. Chairman. Thank you for your testimony. We just received an opposition paper to this, and I'm going to read just one line of it, and I disagree with it because I don't think you can force anybody to do anything. And I was just wondering what AFP or you personally feel about this. It says minimum mandatory sentencing. So they're opposed to this bill. Minimum mandatory sentencing allow/forces people convicted to get treatment. I don't think you can force people to get treatment, can you?
Is there a question there?
That was the question. Can you?
Thank you for the question, Representative. No, I don't believe, and the data does not suggest that forcing individuals into treatment is the best avenue, especially through punitive means where you're imprisoning them. That's not exactly the best incentive towards rehabilitation and taking the approach of getting them the help they need, especially for those first-time run-ins, is the best opportunity to get them out of that cycle. So having a mandatory minimum and putting every single person in the same box without any discretion to the level of crime or the extenuating circumstances is not helping, obviously, and taking this different tact will help to correct that.
Thank you.
Representative True?
Thank you, Mr. Chair, and thank you for taking my question. So would you say that this basically is just removing the mandatory sentencing doesn't necessarily stop the clogging of the courts with cases?
Thank you for the question, Representative. It would help with the backlog, to Representative Warden's point, for that first section. So currently there's an enormous backlog, especially in Hillsborough County and Rockingham County, for these offenses. And to the representative's point of the deputy county attorney, she stated that she sees the same people cycle in and out, and they're not getting the actual help they need. And they get sent to prison, they go to prison, they come back, they relapse, and it's that constant cycle. And they often turn to selling as well to help their habit. That first section will absolutely help with the backlog, because if it's not a felony B offense, then it's not the same degree of caseload that the county attorney's office will have to carry, and it will direct them towards actual means of help. So in terms of that second section with the mandatory minimum, that won't necessarily help with backlog, but it will help with judicial discretion and not putting people who may not be deserving of a 25-year sentence, or maybe they're deserving of much more, that will be the discretion of the judge.
Thank you.
Thank you for your testimony.
Thank you very much.
Scott, say no more pink cards. This time we will adjourn the public hearing on House Bill 1232. At this time, we'll call the order of the Criminal Justice Public Safety Committee. We will now open the executive session on House Bill 1493. Representative Burt, you wish to be recognized to make a motion?
Thank you, Mr. Chairman. I would like to introduce Amendment 2022-0085H.
So are you making a motion of ought to pass?
Yes.
Is there a second to that motion? That has been seconded. That has been seconded by Representative Marston. And Representative Burt, I didn't mean to, excuse me for cutting you off, but you were offering an amendment as well? And you,
Oh, yes. Yeah,
Thank-
so I did it backwards.
amendment now been offered. Do you wish to speak to the amendment?
I'll let you speak on it.
Representative Lang, you wish to be recognized to speak on the amendment?
Yes.
Replacing Section 3, it just allows the Attorney General to exclude any information which would reveal the identity of an informant or compromise an ongoing investigation. Absent that information, they'd have to report everything, and that would potentially put investigations or people at risk.
Representative Newman?
Was the original statement, was that what was there before that should not have been excluded? Does the Attorney General, was that the original statement, and then they added that last line that was important, or a little bit better?
Correct. Section 3, prior to that last sentence, is all identical to the original bill. We just rewrote Section 3 and added that last sentence at the end.
Thank you.
Representative Bolden?
Sorry, just for clarification, so in the strike through in the part of the bill before where this would be inserted, it still remains a strike through. Is that right? And the basically, is this just changing the Roman 3 in the bill and everything else in the bill is the same, or no? Thanks.
If I may, Mr. Chair.
You may.
To answer that question, the bill stays identical. The only difference is on Section 3, we're basically striking all of Section 3 and replacing it with the new Section 3 in the amendment. And the amendment, the only difference between what was in the original bill and the new one is that one sentence about confidentiality.
Representative Marston, you are recognized. Is that? Representative Muse, do you mind reading the results of the blue sheet? For HB 1493? Thank you, Representative Muse. Representative Bolden?
Could you also repeat who made the motion on this and what the motion was?
The motion was made by Representative Burt, and that was seconded by Representative Marston. That's correct. I believe we can, at this point, we can move the question. Seeing no hands raised, this is whether to adopt amendment number 2022-0085H. If you are in support of adopting the amendment, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy. Yes. Representative Welch. Aye. Representative Burke. Yes. Representative Lang. Yes. Representative Green. Yes. Yes.
Yes.
Yes.
Yes.
Yes.
The chair votes yes.
20 to nothing.
Representative Burr, you recognize to make a motion to ought to pass as amended?
Yes, Mr. Chairman, ought to pass as amended.
And is that seconded? That has been seconded by Representative Welch. Anyone wish to speak to that motion? Representative Harry Cathright? Are you asking me about the fiscal note? Representative Testerman?
Somewhere today, there was a spreadsheet of the costs in 2020 of property seized. This was happened to be in Minnesota, but I haven't seen anything as far as New Hampshire.
In respect to a fiscal note, I don't believe if there's any money received through forfeiture that the money's just thrown into a pile. I can imagine that it's accounted for and entered into a system. What's being reported is the total amount of money, not a detailed itemization. So I could imagine that the data entries are already being done. What would have to be part of the report would be a more detailed, it would be the details of those data entries, which is already in the system. Now, whether the software can do that or not, I can speak to that. Representative Lang?
So the reporting requirement is already there. This just changes some of this modifies the way it's done. So the Attorney General already has to report on the asset forfeiture fund, including what's taken, the detailed accounting of what's taken. This adds an expenditure, I think, that I'm not sure is there before, but the report is already required. This changes a little bit of the format and how it's done and the inclusion model.
Representative Harry Gathright, what I was explaining was they're already entering the data individually every time money is received. So it would be in the system. It's just what's going to be part of the report would be the detail of each entry as opposed to just the total amount. Is my understanding what this bill would do if it were to pass. Representative Newman.
Even our testimony that the mic should be on for all of that, is that correct? What's the status right now of the hearing?
As far as I'm aware, there's no formal rule that your microphone must be turned on. I strongly recommend that you turn the microphone on.
Thank you.
Seeing no hands raised, the matter will now be put to question. If you were in support of ought to pass as amended, please say yea. If you were opposed, please say nay.
Representative Burt. Representative Lang. Representative Green. Clerk votes yes. Representative Testerman.
Yes.
Representative True. Representative Pratt. Representative Marston. Representative Harriet Gathright. Representative Pantelakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse. Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley. Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
The chair votes yes. By a vote of 20 yeas and 0 nays, the motion passed. President Klein, you wish to move for consent? Without objection. This time we'll now close the executive session on House Bill 1493. If it's not received by then, it's this time we'll now call the order of the Criminal Justice Public Safety Committee, and we're going to open the public hearing on House Bill 1360. This time the chair recognizes Representative Roy to introduce the bill.
Thank you, Mr. Chairman, members of the committee. For your consideration, I present HB 1360 relative to penalties for controlled drug violations. Similar to the bill we just previously heard, in this bill, I tried to address the issue of making felons out of first-time offenders for a simple drug possession. The difference being that we changed it to a misdemeanor, but we also kept some fine. The previous, as the law is now, is $25,000 up to. And anyone who has any knowledge of the court system or the criminal justice system realizes that those type of fine amounts set up defendants to fail. No one can afford $25,000. Most people I know that have jobs and are doing well cannot just afford $25,000. And the people that are involved in these type of offenses generally aren't overemployed. So we reduced it to $5,000 as a maximum. And that's something that would still have a sting to it, but it would not be beyond the range of possibilities for someone to actually pay their fine. The second part of the bit, we changed it from a Class A to a Class B felony. It's still a felony. It's a second offense. And I'd still be open further to amending that if the committee so thought that was wise. We, again, lowered the fine from $50,000, which, again, sets up a defendant for almost certain failure were such a fine imposed. But we did keep a fine of $10,000. And I kept this one simple. The previous bill we heard, I liked it as well, but with our experience in the previous year with the other body, the more complicated bills tend to get, the more other things get put in with them, and they don't resemble anything we sent over there in the first place. So keeping this one as simple as possible, I think it's a good first step towards lowering our incarceration rates, making felons out of simple possession defendants and setting up people to fail with fines that they have absolutely no way of repaying. And with that, I'm happy to take any questions.
Representative Lang, you're recognized.
I'm just questioning the fine amount on a misdemeanor. Last I remember, the maximum fine by statute on a misdemeanor was, a misdemeanor is $1,200. And does that, in statute, that's what we have under penalty clauses. So does this change that for all misdemeanors, or is this, we're going to call out this one misdemeanor and change it to a new fine amount?
I would say that since it's specific to this statute, it wouldn't impact any other fine amounts. But it's worthy of checking on, for sure.
Representative, we just heard a bill not too long ago, HB 1232. Is there any conflict between the two bills that you're aware of?
Other than the fine amounts, where this bill left some fine, that bill did away with fines altogether. That bill was much more expansive in the things that it touched upon. I'm not aware of any conflicts.
Thank you, Representative. At this time, the chair now recognizes Lieutenant Bill Bright.
Good afternoon, committee. Thank you for hearing my testimony. In reference to, well, for the record, my name is Lieutenant Bill Bright from the New Hampshire State Police. In reference to the first offense and second offense charges of certain narcotics, dangerous drugs being classified as misdemeanors instead of felonies, I would just like to point out that many of these cases in today's judicial system are being negotiated downward already, and changing the jail time and fines to already fit the misdemeanor level offenses. That gives law enforcement and prosecutors the ability of a negotiation tool. Another thing that if we are going to reduce the penalties for these crimes, I think a diversion, a mandatory diversion component of that would be wise to have. And I understand that you can't force somebody to seek counseling or seek help, but at the same time, we're taking away a deterrent that, as in if we make it easier to possess certain narcotics which are dangerous in themselves, opioids, a lot of these drugs, the Schedule 1, 2, and 3 drugs are dangerous in themselves, and taking into consideration somebody's addiction issues that they deal with, I think it would be important to add a component of drug diversion component to a bill like this.
Seeing no hands raised, I want to thank you for your testimony.
Thank you.
This time we can close the public hearing on House Bill 1360. Well, I can just hold it. Nope. We are going to hold a Republican caucus in the room until 2:45. At this time, we will now call to order the Criminal Justice Public Safety Committee. We will now open the public hearing on House Bill 1392. Representative, you here to introduce the bill?
Thank you, Mr. Chairman, and thank you, members of the Criminal Justice Committee. My name is Representative Josh Adjutant, and I am here today to introduce HB 1392, a bill that we hope will reduce drug penalties and decriminalize drug paraphernalia. When Representative Abramson approached me with this bill, I was happy to co-sponsor because I have long believed that drug abuse is not an issue that we can solve by arresting our way out of it or imprisoning our way out of it. Sending somebody to jail for cocaine, heroin, methamphetamine doesn't actually do anything to rehabilitate that person. It's cost to the taxpayers, and it sets them up for future issues down the road where, perhaps rehabilitation isn't for everybody. Perhaps there are some folks that are already, too far gone in that realm and will never be able to come back. But I firmly believe that if we have an opportunity to maybe have somebody get treatment versus jail, it's a benefit to them. It's a benefit to reducing our prison population, and it's a benefit to the taxpayers that don't have to pay for it. I think reducing the fines and turning some things into fines are better for individuals versus steep fines they might face that might have a similar issue, or that might have a similar outcome were they to go to jail. Anybody that's ever been hit with $100, $200, $500 fine for vehicle registration or anything like that knows that that can spiral into a situation where perhaps that person loses their vehicle. It's a similar setup transferred over to this issue. So I'm happy to be one of the co-sponsors on this bipartisan bill, and I would ask that when it goes to exec session, the committee OTB, and I can take any questions.
Representative Burt.
Thank you, Mr. Chairman, and thank you, Representative. If you look at the back, the second page, section 5 or line 5, says relative to advertising. Would that mean, we could advertise any drug on a billboard, or, what would that do?
That I would definitely want to follow up with the prime sponsor on, because honestly, I can't 100% answer that with accuracy right now.
All right, thank you.
Representative Lang.
Thank you. The first sentence, the repeal of the definition of drug paraphernalia, the repeal of RSA 318-B:1X-A. Do you know if that, or are you aware that that definition is used in other statutes to make other cases, things like intent to sell, showing the possession of drug paraphernalia is part of that making of a case? Without a definition, they'd have a hard time defining what drug paraphernalia is?
That's possible. That might be an area for an amendment to simplify that.
If I may inquire, is there any information on how often an individual in New Hampshire is charged with an offense where it's just relating to drug paraphernalia?
I'm going to be honest, Mr. Chairman. Representative Abramson texted me an hour ago and asked me to introduce today, so I did not have the information that I would like to have to answer that question, but I would be happy to follow up the committee after I can take a look at that.
Thank you. Seeing no hands raised, thank you, Representative, for your testimony.
Thank you.
At this time, the chair will now recognize Lieutenant Bill Bright. You're doing a great job.
There you go. You're welcome. Just in reference to this bill, a couple of things that I wanted to provide some information on are, in my 20 plus years of law enforcement, there have been very few instances where drug paraphernalia in and of itself have been used as a chargeable offense, to somewhat answer your question from earlier. But I do believe that it would, leaving the definition of drug paraphernalia would probably affect or be beneficial to other statutes that are out there, as well as a lot of times to have an extra tool as law enforcement is a good thing. And just some of the scenarios that I'm thinking of are, a juvenile who may have drug paraphernalia in a school resource officer needs to have some sort of way to interact with that or take care of that situation. So those were my thoughts on that. And then I'll notice on line 16 and 17 of this bill where it lists what seem like the more serious drugs with a higher fine as opposed to any other controlled drug, which is in line 18. Fentanyl is not listed in that list, which, as I stated in an earlier testimony on a different bill, a very small amount of fentanyl is a fatal dose. So I mean, it only makes sense that would be listed along with the more serious offenses there. And that's pretty much the testimony that I have.
Representative Wallace?
Thank you. So you oppose the bill?
Yes, I mean, generally as a representative of the New Hampshire State Police, I'm here to provide information and, answer any questions that I can help the committee with. In this instance, like, I understand where everybody is going with a lot of these bills. From my own perspective, I like to have the tools in place that if we need them for negotiation purposes or things like that.
Representative Lang?
Thank you. But I, if I'm not mistaken, you said part of this bill would make enforcement of some of the drug, how you manage and create a drug case more difficult?
I think there's a potential for that if a case is built with, not only the possession of the drug itself, but also with paraphernalia that could be, beneficial to a case. But I will say that, most of these, I have never seen anything that has to do with, relative to advertising be enforced or many of these other that are listed here.
One follow-up.
You're recognized for a follow-up.
Thanks. So again, I'm going to go just to that advertising piece. So again, if we pass this bill as it's written, we could potentially see on the side of the roads, buy your bong here.
That appears to be what could happen, yes.
If I may inquire, on lines 12 to 15, and a lot of focus is on the paraphernalia, but from lines 12 to 15, do you have any information or comment on how that section of this bill would change the enforcement of some of the drug laws?
I have not looked at that section in that regard, so I guess I don't have anything to comment on at this time.
Thank you. Representative True?
Thank you, Mr. Chair, and thank you for taking my question. You had, in looking at lines 16 through 19, you had said that it doesn't include fentanyl. You saying it doesn't mention it, or you've looked at all the RSAs and it's excluding fentanyl from this?
From just looking at this bill as it's written, I did not see fentanyl listed, which in my understanding, and if I'm not understanding it correctly, that's fine as well. But it looks like fentanyl would fall under category 2, any other controlled drug.
Thank you.
Seeing no hands raised, thank you for your testimony.
Thank you.
At this time, we will now close the public hearing on House Bill 1392. This time, we are going to open the executive session on House Bill 1392. Representative Roy, you wish to be recognized to make a motion?
I do, thank you. I would move inexpedient to legislate.
That has been seconded by Representative Testament. Anyone, Representative Roy, you wish to speak to the motion?
I will defer to Representative Testament because he just heard the most recent testimony that I wasn't available for.
I'm not going to get to all of it, but, I mean, even allowing road signs, billboards with advertising is bad enough. The issue of essentially giving away drug paraphernalia as a leverage to school resource officers is bad enough. But you get down further and they list several drugs, and I'm not sure if they're all there, but certainly fentanyl is not there. And I don't know what would happen if something worse than fentanyl comes on the market. And so I just think, I don't know what they were trying to do, except feel good. And I know Max, fairly well. But
Let's try not to
Okay.
speak to the motives of members. please.
But in any case, this has got to go. We got to ITL this.
Just to raise a concern, the paraphernalia argument is one, but if you go from lines 12 to the end, I mean, essentially, if there's any type of drug transaction or drug offense that doesn't involve an act of violence, the penalty's going to change to $40 per gram or $20 per gram, depending on the type of substance. I think I understand the motivation, but I think that's going too far too quickly. I'm not sure if someone interprets it any differently than I did, but. I think that's a extreme direction to go from where we are now to that, in one swoop. Seeing no, for Representative Bolden.
If I understand correctly, the concerns about fentanyl, my understanding, for example, is that methamphetamine came about when cocaine was made illegal as an alternative to cocaine that was not yet illegal. And methamphetamine presents a whole host of problems, obviously worse than those presented by cocaine. It seems that similarly, the inability to access less dangerous opiates has led to the use of fentanyl, which is otherwise regularly used medically. There are cancer patients that wear fentanyl patches because of the extreme pain of the process that they're going through. So I wonder if there was less personal liberty at stake in using the less dangerous drugs, if people would opt for them more often and would be less inclined to take risks with drugs like fentanyl. Just a thought to throw out there. Thank you.
Representative Roy, you're recognized.
The representative makes a good point. However, the problem with opiates is not only are they addicting, there's also a tolerance level. So even making OxyContin legal, what would happen is you'd eventually build up such a tolerance level that you would naturally have to go to something stronger, and you'd be directed to fentanyl anyway. They build an incredible tolerance quickly. So being able to, saying that, well, maybe they'll stop at that, it would be great, but unfortunately the body builds such a quick resistance to it. That's why people that are on opioids, prescription opioids, generally at least once a year have to up their amount to get the same relief from the pain. And the same thing goes for people that use it recreationally. They need more and more and more to get high. Eventually they end up on fentanyl or heroin anyway. So that's my 2 cents on that.
I would just point out lines 25 to 27 also would conflict with the last 2 bills that we heard. Being House Bill 1360 and House Bill 1232. So again, it would be hard to support this. You would have to make an amendment and strike that language out. Representative Bolden.
Seeing as we can't guarantee how any particular bill is going to pan out, we have to only vote on the bill in front of us. But I just thought it might be worth clarifying my comments earlier. I think that fentanyl is known to be more dangerous than other opiates. And so I think that from the perspective of risking your life by using the only drug you can find or being sober, I think that they would be more likely to unfortunately choose the more life-threatening option. And I would hope that if there were less personal liberty at risk, a lower likelihood of imprisonment if they choose a different drug, then they would go for the less personally dangerous drug, not tolerance levels notwithstanding. Thank you.
This time the matter will now be put to question. If you're in support of the motion of inexpedient to legislate, please say yes. If you were opposed, please say nay. The clerk will now call the roll.
Representative Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Lang.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt. Representative Marston.
Yes.
Representative Harriet Gathright. Representative Pantelakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse. Representative Newman. Representative Bolden. Representative Conley. Representative Klein Knight. Representative Bradley. Chairman Abbas.
The chair votes yes.
The vote is 17 to 1 and 3 not votes.
Do you have an objection to consent?
Representative Roy moves for consent
He does.
without objection. This time, Representative Roy, will you be preparing a majority report?
I will.
At this time, we will now close the executive session on House Bill 1392. Representative Burt?
Are we going to vote like this all year?
I hope so. Yes. At this time, we'll now open the executive session on House Bill 1232. Representative Roy, you wish to be recognized to make a motion?
I do. I move interim study.
Is there a second? That motion has been seconded by Representative Welch. Anyone wish to speak to that motion?
I would say that we heard testimony on another bill, 1360, that is currently in drafting for a small amendment. It's much simpler. It still starts us down the correct path of reducing the felony sentences without becoming so complex as to have a little chance of coming out the way it left once it reaches the other body. So for that reason, I would suggest that we interim study this and we take up the next one, 1360, when it comes down.
Representative Testament?
I was just going to ask what the strategy was here, and basically put this aside and take care of 1360 with amendments. Okay.
And it should be coming down any second.
Seeing no hands raised, the matter will now be put to question. If you support the motion for interim study, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Representative Burt. Representative Lang. Representative Green. Clerk votes yes. Representative Testerman. Representative True. Representative Pratt. That was a yes. Representative Marston. Representative Harriet Gathright. Representative Panalakis. Representative O'Hearn. Representative Bourdonnais. Representative Muse. Representative Newman. Representative Bolden. Representative Conley. Representative Klein Knight. Representative Bradley. Chairman Abbas.
The chair votes yes.
Once again, 17 to 1, 3 no votes.
Yes, you may.
Consent. Do we need consent for interim study?
Representative Roy, you wish to move for consent?
Yes.
Without objection? So
Amanda
moved.
didn't object. She's okay.
Without objection?
You okay? Okay.
So moved. This time we will now close the executive session on House Bill 1232. Representative Harry Gathright? $17 to 1. Oh, 1392.
Yeah, 17 to 1.
Also 17 to 1.
17-1 and 3 no votes.
Representative Testman, do you wish to draft a majority report? Interim study of House Bill 1232.
I'll be sure.
Thank you, Representative Testman.
Yeah.
Yes, you do, Representative True.
Stand in recess.
We'll stand in recess for to 3:30. this time, we'll call the order of the Criminal Justice Public Safety Committee. And we will now open the executive session on House Bill 1360. I understand that Representative Roy wishes to make a motion that he'll, if someone would like to make that motion on his behalf, that would be,
He makes a motion of, ought to pass with amendment?
and is some, was,
Yes. And
Representative Roy, you're recognized to make a motion.
I move, ought to pass on the amendment 1360, amendment number 0088H.
and I'll second.
And that has been seconded by Representative Burt. And you're offering an amendment. It's clarifies 2022-0087H. Do you wish to speak to your motion, or to the amendment?
Yes, thank you. 60 first. Yeah, 88H Hotel. So after discussion during the hearing, there was some discussion about the fines, and Representative Lang pointed out that these fines are not the standard fines for felonies and misdemeanors in our statute. They had been at some point in the past artificially enhanced. 50,000 and 25,000 are not the fines that are defined in statute for every other felony and misdemeanor. So what we did was we just took out the number amounts so that it is up to the judge to decide the fine based on the existing statutory fines for misdemeanors and felonies, which are $1,200 for a misdemeanor. Is that correct?
Representative Lang, you wish to be recognized?
Correct, thank you. So for, correct, for a misdemeanor, depending whether it's A or B, it's a $1,200 fine, $1,000 fine, or $200 penalty assessment for an A, or for a B misdemeanor, it's a $1,000 fine max. For a violation, it's a $1,000 max. So this would put this law into alignment with our standard fine and penalty schedule rather than any special enhanced penalties.
Thank you. And that was all I had for the amendment.
Seeing no further hands raised, the matter will now be put to question. If you are in support of adopting amendment number 2022-0088H, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Yes. Representative Burt.
Yes.
Representative Lang.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt. Representative Marston.
Yes.
Representative Harriet Gathright. Representative Pantelakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse. Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley. Representative Klein Knight. Representative Bradley. Chairman Abbas.
Chair votes yes.
18 to nothing. 3 not voting.
The motion to pass the amendment, or to adopt the amendment, is passed. Representative Roy, do you wish to make a motion of ought to pass as amended? That motion has been seconded by Representative Burt. Any additional, wish to speak to your motion, or any additional comments?
No, negative. I think at this time we've pretty much discussed it. I don't have anything to add. Someone else may.
As courtesy to the two members that walked into the room, Representative Roy, do you mind just explaining the motion that is pending?
Sure. The pending motion is an amendment to HB 1361, no, excuse me, 1360, and it is amendment number 0088H. After the hearing and some discussion, we decided that rather than set specific fines, looking at the statute as it is, in our criminal statutes, felony and misdemeanor already have assigned fine amounts. And at some point in the past, they were inflated specifically for drug crimes to $25,000 and $50,000. So we thought it best to just go back so that it fell in line with the rest of the statutes for felony and misdemeanors, which are substantially less. So we took the fine amounts out, and it's up to the judge on what amount he would like or she would like to impose. And we just passed that amendment 17-0, correct?
18 to 0.
18, I stand corrected.
3 no votes, not voting.
And the current motion is ought to pass as amended.
Okay, then.
Well, please state your point of order, Representative True. Yes. The question has not been, we haven't moved the question yet. So therefore, if the member's in their seat, once the question's moved, then they're permitted to vote. This time, the matter will now be put to question. If you in support of the motion of ought to pass, please say, ought to pass as amended, please say yea. If you are opposed, please say nay.
Vice Chairman Roy,
Yes.
Representative Welch. Yes. Representative Burt.
Yes.
Representative Lang.
Yes.
Representative Green. Yes. Clerk votes yes. Representative Testerman.
Yes.
Representative True. Yes. Representative Pratt. Yes. Representative Marston.
Yes.
Representative Harriet Gathright. Representative Pantelakis.
Yes.
Representative O'Hearn. Representative Bourdonnais. Yes. Representative Muse. Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley. Representative Klein Knight. Representative Bradley. Chairman Abbas.
The chair votes yes.
19-0, 2 not voting.
Move to consent by Representative Roy. Thank you. This time, we'll now close the executive session on House Bill 1360. At this time, we will now open the executive session on House Bill 1361. Recognize Representative Roy to make a motion.
I would like to move amendment number 2022087H, is that right? On HB 1361.
So you make a motion ought to pass and you wish to offer an amendment. Is there a second? That
I
is,
passed it out, you have it.
that is seconded by Representative True.
Shall I speak to my amendment?
Representative Roy, you wish to speak to your amendment?
I do, thank you. As I said during the introduction of the bill, this creates a separate charge for anyone importing drugs, controlled substances into the state of New Hampshire for the purpose to sell. The amendment changes the original bill, and this amendment totally eliminates cannabis-type drugs from the bill. The reason for that being there are surrounding states and there are issues regarding how much someone can possess underneath the medical exception in this state versus other states, and there are also different cannabis products such as edibles and such. So we felt it best to just leave cannabis out of it. So the remaining drugs on the schedule are still there. And so what this is you would have to have an amount that would constitute distribution for this charge to apply, and that's it. Oh, I would add one more thing. As I said, for some folks who may not have been here, I did a lot of research on this, and there are many states that have crimes like this, including California, where they charge you there's an extra charge, criminal charge for importing drugs into the state for distribution. So we would not be by any stretch of the imagination breaking new ground with this.
Representative Conley, you recognized?
Thank you, Mr. Chairman. This question is for the sponsor, if I may. And forgive me if you addressed this earlier, but I mean this truly in good faith, I don't understand the need for this bill. Would this not be covered under a federal statute already? Would our existing trafficking statute not address this? Can you help me understand why this particular law would be necessary and how it might be applied? Would this be tacked on to separate drug charges? Would this be a standalone if I had, a large quantity in my vehicle and I was on exit 2? I'm just really trying to better understand it.
No, sure, and that's absolutely right. So the reason for the bill in the first place is, as we all know, we have an incredible opioid crisis in the state, among other things. And we also know that the vast majority, and this has been held up by law enforcement and the courts, the vast majority of our drugs are coming from across the southern border or across the border. They're not made here, manufactured here, they're being brought in. So the impetus for this bill, and we've tried a million other ways to try to get a handle on this opioid crisis, this hopefully would be something that would at least create a hesitancy in someone, say, from Lowell or Lawrence loading up their car, heading up to Nashua with a car full of drugs. This would be an additional charge available to law enforcement. It wouldn't be in lieu of, it would be in addition to the existing, and it would create a Class A felony, and their vehicle would be subject to forfeiture that they were using to transport the drugs in.
And if I can just clarify, the question that we're going to move is whether to adopt the amendment, which is the same as your underlying bill, we're just removing cannabis from it. So you may have some issues with the underlying of the policy as a whole, but I get the feeling that some members may at least be fond of the amendment by excluding cannabis.
Point well taken, Mr. Chairman.
Did you see Nicole out there? Did you see Nicole out there?
I don't know what the green means.
There's a limit?
At this time, the matter will now be put to question. If you're in support of adopting amendment number 2022-0087H, please say yea. If you are opposed, please say nay. Clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Representative Burt. Representative Lang. Representative Green. Clerk votes yes. Representative Testerman. Representative True. Representative Pratt. Representative Marston. Representative Harriet Gathright. Representative Panelakis. Representative O'Hearn. Representative Bourdonnais. Representative Muse. Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley. Representative Klein-Knight. Representative Bradley. Chairman Abbas.
The chair votes yes.
19-0, 2 not voting.
Representative Roy, you wish to make a motion ought to pass as amended?
Yes, I'd like to move ought to pass as amended.
Representative True, you wish to second that? That's been seconded by Representative True. Representative Roy, you wish to speak to the motion?
As we just said, that this amendment pretty much replaced the entire bill, so it's the same thing we already discussed. So unless anyone else has any further questions or, I'm good.
Representative Bourdonnais?
Thank you, Mr. Chair. I can't support this bill. I supported the amendment because it did improve the bill, but I don't think this bill is necessary.
Representative Harry Gathright? Representative Roy?
Thank you. If I could just address the federal question. To get the U.S. attorney to take up a case is really requires a divine intervention, unless it's a really, really large amount. Second of all, well, first of all, that applies. In other words, a New Hampshire police officer would have to make a stop, make an arrest, and someone would have to reach out to the U.S. Attorney's Office and see if they were interested in prosecuting the case. There is no policing of the interstate borders by federal law enforcement, unless it's an ongoing investigation where they're actually following someone back and forth. So it really is up to the own states to try and police what gets into their state. Otherwise, we would see a lot less drugs and a lot more federal prosecutions, but we don't, unfortunately. I agree that it would be, in an ideal world, the DEA would handle all these and the U.S. Attorney would be prosecuting them. But it's just not the case. It's not happening.
Representative Lang?
Thank you, Mr. Chair. Again, I agree with Representative Roy that getting the U.S. Attorney Office involved in a drug case is next to impossible unless you're dealing with a truckload of drugs. Addition to that, understand that this is a mechanism to keep people from transporting into the state, right? That's the goal of the bill, is to add a penalty. So you bring drugs into the state, not only going to be charged with the drugs, you're going to be charged with the transportation of those drugs into our state. Keep your drugs in your own state. You want to sell them in your state, let your local police or state police deal with it. But New Hampshire's going to crack down on this, and I think this protects our citizens from those people who would choose to come up from different parts of the country.
And just to speak on that, Representative Lang, it's a point well taken. I've never heard of a situation where someone manufactured or created fentanyl in the state of New Hampshire. I feel like that would have made the paper. So that's being imported from out of state, and it finds its way here, and there's people dying. So this is the hope to deter that. Representative Burt, you're recognized.
Thank you, Mr. Chairman. I do have a question. What is the amount that would have to be brought across the border, in order for this to kick in?
Representative Roy, you may respond to that.
Representative, thank you for the question. It's really different according to each drug, how much the threshold is for intent to distribute. And the court has certain guidelines they go by where it's not statutorily spelled out specifically, like was it packaged for individual resale? How much was it that it was obviously not for your personal consumption? So it's a kind of a case-by-case basis on each one's different.
All right. So there's no set amount then?
No, there's no set amount that would trigger it.
It's a totality of all the information available. Having large sums of cash if you have a controlled substance in a bunch of different bags, having a scale is often a sign of, it's evidence of distribution, or the intent to distribute.
And one other question?
Yes, you're recognized.
All right, thank you, Mr. Chairman. On the seizure of the car, is that already law? This just, keeps it in line?
I believe it is, right? Yeah.
My understanding is that if you're using a motor vehicle in the course of using it to actually sell or distribute drugs, then it can be seized, yes.
Yeah, currently.
All right, thank you.
And the feds seize that and homes and everything else.
Representative True?
Thank you, Mr. Chair. Mr. Chair, this is more of a question to you. Can you tell me what the current law is in New Hampshire for intent to distribute?
It's under the chapter that's actually listed, 318 B. But I just explained that it's a totality of the circumstances. They're not going to just define it specifically as what constitutes possession with intent to distribute. What it is that you can have a very small amount of a controlled substance, but if you have a scale and it's in 15 or 20 different bags, that could be evidence of possession with intent to distribute. It doesn't necessarily mean that you are, but it can be. Representative True?
Thank you, Mr. Chair. No, I mean, is it a Class A felony? Is it a Class B felony in New Hampshire to be charged with the intent to distribute?
Representative True, Representative Roy, you may respond.
I have just been informed that it is already a Class A, so this is not a, intent to distribute is a Class A right now.
Representative Conley?
Thank you, Mr. Chairman, and I'm glad that the representative mentioned that. So it's already a Class A felony to have a certain quantity of drugs with the intent to distribute. Hitting someone with a second felony, I'm not sure what the net effect of that is. I really do believe this is well-intentioned, but it's already covered under existing statute. It creates a mandatory minimum that members of both parties have worked to get rid of and remove. And it's, I think, vague on substance. We just learned from the chairman that even a small substance of this could trigger this under the statute. And as I read it, it would need to already be paired with an existing Class A felony. So with that, I won't support this, and I'll stop there.
Representative Roy, you may respond.
You are correct. It would be 2 felonies. This is an enhancement, and it does, you're also correct, it creates a minimum mandatory. And you're also correct that we are trying to get away from a lot of minimum mandatories. But that doesn't mean every single one. And we have so many people dying right now in this state of drugs that are coming across our border, so as to rival some of the other most recent causes of death. And those we can't do anything about, but this we can. And if we can at least discourage somebody and they say, wait a minute, if I get caught going across the border with this, I'm doing 5 years and I'm losing my car. I feel like it's the least we can do to try and protect our children and the people of the state that are dying on a regular basis. And it's overwhelming our first responders. That's all.
And I can just speak to that we're, based on the community that I live in the district that I represent is a border town that's not too far from an area where drug trafficking, specifically fentanyl, has been widely publicized as a huge problem. So, again, the fentanyl's not made in New Hampshire. I've never had any evidence of that, but it's being brought here and imported here. And that the mere fact that you're bringing the fentanyl to this state is what I'm really focusing on. And that's what's killing people. Representative Bolden, you're recognized.
But doesn't this bill cover more than fentanyl? Is that right?
It does.
Thank you.
Representative Lang, you're recognized.
So the only thing I say, again, as an element of the crime, they have to prove as part of this transportation is the intent to distribute, right? The intent to sell. So again, we're talking about commercial drug dealers who are coming in from out of state to sell to our citizens. And this law goes, it would be an enhanced penalty to say, stay in your own state. Do it there. Don't come here.
Representative Newman.
What effect would this have on someone who goes to Massachusetts or Lowell and maybe is a user and they prepackage some and there's a limited amount of, there's a certain amount of, maybe a scale is involved or whatever the circumstances are that would prove that they would come back and then be punished by not only a felony but the minimum felony and all of that. Absolutely, the most egregious thing I think here is the minimum penalty. I just won't be able to support this bill.
Representative Pantelakis? Representative Conley?
Thank you, Mr. Chairman. Very quick. The one final point I would make is that the kingpins, the real bad actors, are not the ones behind the wheel. These are low-level people who are not actively engaged, typically, not always, typically not actively engaged, who are doing the transportation. This is not going to stop the flow of drugs into our state. It is just going to mean more people serve more time for it, while the next person in line willingly grabs the wheel and makes the next delivery. And I wish it weren't so, but it is.
At this time, the Representative True, you are recognized.
I apologize. A question of the chair, because you're a lawyer. A Class A felony conviction will result in a 7.5-year incarceration of not more than 15 years and fines of up to $4,000. So how would this work? That if you're found guilty of importing with intent to sell and intent to sell, you would get 7.5 years at least, plus a minimum of 5 years? How would the judge rule on that?
There can be concurrent sentences and consecutive sentences.
And you could suspend one or the other, right? Yeah.
I'm not sure if they can
Yeah.
suspend it all the way.
May I?
You may respond to that.
It's my understanding that on the Class A felony, the one that Representative True just brought up, the first instance, it's not a mandatory, so it could be suspended. This is mandatory, so there'd be no option to suspend it or put them on double secret probation or anything like that. Versus the other one, if they're incarcerated, they will be incarcerated for 7.5, but it's not a given that they will be incarcerated.
Representative Bolden?
Thank you. So is the assumption here, or the hope, is that when a person is considering moving drugs across state lines, their knowledge that it's 2 felonies instead of 1 will dissuade the behavior? The first felony didn't do it, but the second one will? Is that the hope?
Representative Roy, you may respond to that.
No, I think the hope is, first of all, the mandatory. The first one, anyone with any experience in the criminal justice system, you'll see many times they'll plead. In other words, you'll arrest somebody with intent to distribute, and the majority of the time, those first few offenses are going to get pled down to just possession, just to dispose of the case. So they know that there's a good chance that they're not going to do time on an intent to distribute case unless they have an extensive record. This, my hope is that they'll say, wait a minute, if I get caught with this, I am doing 5 years. And that will dissuade them. And likewise for the vehicle forfeiture as well. Because a lot of times we see people, I don't want to use the word mule, but they'll get someone else to drive them because they don't have a car, or, well, that person also might have a second thought and say, no, I'm not taking you anywhere because we're both going to be 5 years. As the previous bill where we reduced the sentence for first offenders, first-time offender, simple possession, I think at the same time we have to toughen up on the dealers. If we're going to, we can't go easy on everyone. If we're going to try and give a break and look more towards rehabilitation of these simple possession offenders, we have to at the same time stem the flow. Otherwise, it's just going to be a revolving door. But that's my opinion.
And we did hear testimony, and I apologize if it was not on this bill, but on one of the bills, that when you have a penalty of this nature and someone is perhaps stopped or arrested, when they're facing a sentence like of that nature, is how law enforcement often can gather or get informants. So that person's facing cooperate, or this is what they're going to face. So that also gives law enforcement more to work with as well. Representative Bolden.
So I'm hearing that if we double up on the felonies and take their cars, they won't bring the drugs across the border, but when they still do, even though they won't, when they still do, we'll have informants. And so those people who violated the law will not be punished. So they won't do it, but when they still do, we won't punish them, is what I'm gathering here. And it's just very confusing, especially considering what Representative Conley mentioned, that these people that are arrested for this are typically unwitting drivers, probably trying to make money for their drug habit, and they're not the dealers, they're not the kingpins. So this doesn't seem to address the kingpins whatsoever. And I think overall what I seem to be hearing is that this is an enforcement issue, really. This is a court issue. This isn't a legislative issue. So I have concerns that this bill will have the intended effect.
And just to clarify, I'm not suggesting that a person who violates this law will not be punished. That is within that's something that the county attorney or the attorney general and law enforcement, that's out of the scope of what we're covering here. But that does give law enforcement another tool in the overall fight against the drugs that they're dealing with. Representative Klein Knight.
Thank you, Chair. Is there any sort of data involving how this may have impacted another state, or another state has adopted this language and how it has affected their prison population?
I can tell you that there are many states, including California, Florida, Texas, that have adopted this. I can't speak to how that would require really an in-depth study to be able to isolate out what exactly affected the population or not, or and how. But I can tell you there are other states that have it.
You wish to have a follow-up?
Thank you. With due respect to the bill and the sponsor, do we have to exec today, or is there more research we can do?
I think we've had a plenty of discussion on it. So at this point, I think Representative Pantelakis. My understanding yes, it's targeting individuals who are importing drugs with the intent to distribute those drugs in the state of New Hampshire. So those drugs, in all likelihood, are not manufactured or cultivated or whatever in this state. They're brought in this state, and this is an additional penalty in addition to possession with intent to distribute. At this point, unless if you have not spoke already, I think we can now move the question. If you're in support of
Point of order, Mr. Chairman.
You're recognized for your point of order.
It's my understanding that we can't move the question in committee, that's only a motion for the floor. Is that correct?
It's true, but he can call the vote whenever he wants.
I believe, are you believing that what rule am I not following? I don't follow. There can't be a motion for the chair to move the question, but the chair has the discretion to move the question at their own discretion. So as the chair of the committee, I'm moving the question.
Is this not a deliberative body where we deliberate?
I'm not following what, you asked the question about what discretion I have to move the question. I just answered your question. So I'm gonna overrule your point of order. This point, at this time, the matter will now be put to question. If you're in support of the motion of ought to pass as amended, please say yea. If you're opposed, please say nay.
Vice Chairman Roy. Representative Welch. Representative Burt. Representative Lang. Representative Green. Clerk votes yes. Representative Testerman. Representative True. Representative Pratt. Representative Marston. Representative Harriet Gathright. Representative Panalakis. Representative O'Hearn. Representative Bourdonnais. Representative Muse. Representative Newman.
No.
Representative Bolden.
No.
Representative Conley. Representative Klein Knight.
No.
Representative Bradley. Chairman Abbas.
The chair votes yes.
With a vote of 12 to 8, it passes, and one no vote, non-voting, that is.
Representative Roy, you'll be preparing the majority report? Will someone be preparing a minority report? Going forward, I wish for that to be assigned right away, because last fall, I spent more time tracking down the reports than it would have taken me to write both of them. Which, Representative Bolden, thank you. And try to submit that before the end of the day today, but if it's not received by noon tomorrow, I'm not going to accept them, because we've had reports that are a month overdue. We now close the executive session on HB 1361. It is. Well, no motions needed. We are adjourned.